One, two. Platform, can you hear me?
Loud and clear.
Speaker mic platform, can you hear me?
You are live, sir.
Recording in progress.
Speaker.
There'll now be a moment of silent prayer and meditation. May we be seated? Order, honorable members. The first item on the order paper is a motion in the name of the Chief Whip. Deputy Chief Whip.
Thank you very much, Honorable Speaker. I move that the House notes that Section 1 of the Parliamentary Villages Management Board Act 1998, Act number 96 of 1998, defines parliamentary villages as Acacia Park, Laboria Park, Pelican Park, and any other place of accommodation for parliamentarians and sessional officials declared as such by the Minister of Public Works. The Act does not have any provision that determines who qualifies for accommodation in the parliamentary villages. And considering the context and history of the Act, it is a reasonable interpretation that persons who qualify as residents do not include support staff of political parties or support staff of presiding officers in Parliament. Further notes that this implied exclusion poses challenges for support staff of political parties and presiding officers whose primary residence is outside Cape Town, as they are not within the categories of persons specified in the Act, but are required to be in Cape Town to carry out their work. Realizes that in the absence of a clear prescription or prohibition in the Act regarding which categories of persons may or may not reside in parliamentary villages, a review of the Act should be undertaken to bring about greater clarity. That the House resolves to establish an ad hoc committee in terms of the National Assembly rules, Rule 253, subsection 1A, to review and amend the Parliamentary Villages Management Board Act, Act number 96 of 1998, among others, to enable support staff of political parties and support staff of other parliamentary office bearers, such as presiding officers, to be accommodated in the parliamentary villages, and review the composition and functions of the Parliamentary Villages Management Board to provide more representation for the administration of Parliament to ensure that the board is effective in the execution of its function. Exercise any of the powers as set out in Rule 167 that may assist in the carrying out of its task. Consists of 11 members as follows: ANC 4, DA 2, MKP 2, EFF 1, and other parties 2. Sets the deadline by which the committee is to report to the House as the 31st of March 2026. I so move.
Thank you, Deputy Chief Whip. I now put the motion. Are there any objections to the motion? So since there are no objections, the motion has been agreed to. And we would like to thank the House Chairperson for Internal Arrangement, Honorable Horn, and the members of the Internal Arrangement Committee, as well as the Board of the Parliamentary Villages, for having dealt with this matter and find a better way in which the stalemate can be resolved. Thank you very much. Now the Secretary will read the first order.
Consideration of the report of the Portfolio Committee on Home Affairs on the Immigration Amendment Bill.
I now recognize the Deputy Chief Whip.
Honorable Speaker, thank you. I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objection. Oh, sorry, Honorable Trollip. Okay. Objections have been noted from the Action Essay. Honorable Douglas. MK also objects to the report. Thank you very much. Those objections have been noted. We can now proceed to the second order.
Second reading.
Sorry, Honorable Trollip.
Sorry.
I didn't agree to the report.
I thought you were busy with the second report.
No. Remember that
you
first.
asked for no objections and there were none. You asked for if there were no objections, there were none. When you asked for the second time, I thought you were asking for
Oh, no,
objections for the
not
second
yet.
vote. Okay.
First, there was a motion.
I withdraw that.
Okay.
We have
There was
support
first
from
a motion of the report. So, Douglas, do you also want to review your withdrawal?
Honorable Speaker, just confirm again the numbers so that we can just see what exactly it is that we are voting on.
Okay.
Because
Remember, we read the first
yes,
order, which was
there was no objections to the
which was the motion in the name of the Chief Whip regarding the report.
the parliamentary report on.
No, hello? Yeah, the motion about the parliamentary villages, there was no objection.
That's correct. That's correct.
Yes. So I asked the secretary to read the first order, which is on the report on Portfolio Committee on
And that-
Home Affairs.
And that we object to. That's correct. Yes, we object to it.
that motion?
So do we, Honourable Speaker, on the first order of the day.
That's where I was. And
where
that's why
thought you
I
were.
said I noted your objection is action SA and the MK. We've noted your objections, but the report has been agreed to. Okay, so we're all at one now. Okay, now we can ask the secretary to read the second order.
Second reading debate, Immigration Amendment Bill.
Thank you, Honorable Minister Schreiber, Minister of Home Affairs. Happy birthday to you. Today is the birthday of Honorable Schreiber. Yes,
Thank you very much, members.
happy birthday to you, Minister.
Thank you, Honourable Speaker, and what a gift it would be for us to pass this bill today on my birthday. Honourable Speaker, honourable members, I rise today to table the Immigration Amendment Bill 2024. The bill seeks to align Section 34(1) of the Immigration Act 2002 with constitutional imperatives as set out by the Constitutional Court in two important judgments. While limited in scope, the bill we are considering today serves as a testament to our commitment to the Constitution and the rule of law. Its genesis traces back to a 2017 ruling in Lawyers for Human Rights versus Minister of Home Affairs and to a 2023 ruling in Minister of Home Affairs versus Lawyers for Human Rights. In both of these judgments, the Constitutional Court found that the Immigration Act needs to be more strongly aligned with the provisions of our Constitution. In its 2017 judgment, the Court declared Sections 34(1)(b) and 34(1)(d) of the Immigration Act unconstitutional and invalid due to their inconsistency with Sections 12(1) and 35(2)(d) of the Constitution. The Court found that these provisions failed to ensure that detainees are informed of their constitutional rights, including the right to legal representation. Moreover, Section 34(1)(b) did not provide for automatic judicial review of detentions within 30 calendar days, nor did it allow detainees to make representations or appear in person before a court. It also denied detainees the opportunity to challenge the lawfulness of their detention by appearing in court or making representations on the grounds for their detention. The Court further noted that Section 34(1) of the Act lacked objectively determinable conditions or guidance for the exercise of detention powers, rendering it unconstitutional. To afford Parliament time to address these defects, the Court suspended its declaration of invalidity for 24 months until the 28th of June 2019. It further ordered that pending remedial legislation, any suspect detained under Section 34(1) must be brought before a court in person within 48 hours of arrest or on the first day thereafter if the 48 hours expire outside ordinary court days. Unfortunately, Honourable Speaker, the necessary amendments were not made before the expiry of the initial 24-month period. However, even after the lapse of this initial 24-month window, Home Affairs continued to uphold the guidelines that were issued by the Court, preventing any gap in the law from arising. In an important demonstration of this administration's commitment to restoring and upholding the rule of law, the amendment tabled before the National Assembly today will finally ensure full implementation of the Constitutional Court's findings. The amendment has also been informed by the subsequent 2023 ruling by the ConCourt, which clarified and supplemented the original 2017 order under Section 1721(b) of the Constitution, providing amplified, just and equitable relief. Therefore, the Immigration Amendment Bill before this House today addresses the constitutional requirements set out in these two cases by amending Section 34(1) of the Immigration Act. The bill ensures that any illegal foreigner detained under this section is brought before a court in person within 48 hours of arrest, allowing the court to determine whether further detention for deportation is in the interests of justice. It introduces this concept of the interests of justice as an objective criterion to guide both immigration officers and courts thereby providing the Department of Home Affairs and other role players with a clear standard to meet and introducing greater predictability to the deportation process. Importantly, in addition to upholding the rights of the detained, the introduction of this heightened level of objectivity makes it much harder for any immigration officer to arbitrarily release detainees before they are deported. As Minister, I will use this new law to introduce regulations that strengthen our ability to uphold the rule of law and deport those who are in South Africa illegally. Additionally, upholding these objective standards will ensure that detentions and deportations stand up in court, reducing the litigation costs and delays involved in legal appeals. I wish to extend my appreciation to Deputy Minister Njabula Nzuza, the Portfolio Committee on Home Affairs chaired by the Honourable Moza Chabane, as well as to the Department for their work in ensuring that we finally bring this matter to a close. For the first time, Honourable Members, we will now have a clear set of deportation rules endorsed by the Constitutional Court. In time, this will make for a stronger immigration enforcement system that reduces legal claims against the department while enhancing our ability to carry out legally compliant deportations more effectively. This amendment is one component of the bigger package of reforms that the Government of National Unity is working on to modernize our immigration system. It will be followed by the publication for public comment of a draft supplementary white paper on citizenship, immigration, and refugee protection, as well as by the imminent introduction of the electronic based on secure biometrics. I also want to use this opportunity to call upon this House to ensure that the Border Management Authority, which has already registered important successes through its embrace of digital transformation, is urgently funded and capacitated so that it can implement its comprehensive modernization plan to build a secure digital border environment. Taken together, Honourable Speaker, these reforms have the power to shape a fundamentally stronger immigration system, anchored in the Constitution and the rule of law, while using digital transformation to enhance law enforcement and secure border management. I want to encourage members of the House to support this bill's passage as a clear signal of our collective determination to modernize and strengthen immigration management, the deportation, as well as the rule of law. I thank you.
Thank you, Minister. Honorable M.S. Chabane, the chairperson.
Thank you, Honourable Speaker, honourable members. The Portfolio Committee on Home Affairs presents this report on the Immigration Amendment Bill, which comes at a time when the country continues to face pressing challenges related to migration. The bill is a technical amendment. It only seeks to comply with the Constitutional Court order, and it does not seek to amend the entire Immigration Act. The House has initiated this legislative intervention to strengthen our immigration protocols with the dual aim of protecting the Republic and promoting inclusive economic growth. This bill builds upon the previous efforts, including the passing of the Border Management Authority Act, as the Minister has highlighted, and currently the committee is processing one-stop border posts as an effort to complement the laws of this country. Pressured by the concerns of South Africans, the Department of Home Affairs, under the ANC leadership, has undertaken in the 6th administration a comprehensive review of White Paper on Citizenship, Immigration, and the Protection of Refugee Act, which is delayed, the Minister, for the bill to be tabled limits this House to amend the existing legislation to respond the path this country should take in managing the broader migration landscape. On the 29th June 2017, the Constitutional Court, in a matter of law for human rights, and the Minister of Home Affairs and others declared Section 34, subsection 1B and D of Immigration Act, as the Minister has highlighted, to be inconsistent with the Section 12, subsection 1 and 35, subsection 2D of the Constitutions. These sections were therefore ruled invalid, and in 2023, a supplementary order was issued by the Constitutional Court. The key aspects was the unconstitutionality of powers of immigration officers to detain individuals based on a declaration of being illegal foreigners without proper administrative procedures. The Immigration Amendment Bill seeks primarily to address these unconstitutional concerns by revising the provision relating to the arrest and detention of illegal foreigners for the purpose of deportation. It aims to align the legislative framework with constitutional rights, particularly those enshrined in the Bills of Rights. As the hallmark of our democratic process, the public participation was central to the work of the committee. After being briefed by the Department of Home Affairs, we advertised the bill widely, inviting submissions from interested persons, institutions, and stakeholders. The committee received a total of 378 written submissions on technical aspects and further conducted oral submission as mandated by the Constitution, reflecting on the broad range of views. These inputs touch both on the specific content of the bill and the broader immigration policy concerns. The latter was referred to the ongoing white paper review process as they fell outside the scope of the bill. A number of substantive issues were raised during the deliberations, particularly in relation to the interest of justice. There were divergent views regarding where the clause should be codified and whether its broad nature could lead to subjective or inconsistent application. In response, the committee revised the clause to empower the Minister of Home Affairs to issue regulations guiding immigration officers on how to exercise their discretions consistently in determining whether the arrest of illegal nationals and release of detainees is in the interest of justice. And this is to ensure transparency and consistency in the application after the President has signed into law. The committee also considered the submission related to the treatment of foreign children, especially unaccompanied minors. Concerns were raised that the bill will lead to the automatic classification of undocumented foreign children as illegal foreigners, potentially resulting in detention in adult facilities in violation of both the Constitution and international obligations. The committee emphasized that children should never be treated as criminals for immigration violations. Detention must also be measured of a last resort, and children must be placed in shelters and treated as children in need for care and protection under the Children's Act of 2005. The amendment introduced, amongst other several important changes, to ensure constitutional compliance to the extent that immigration officers must bring an arrested illegal foreigners before the court of law within 48 hours of arrest. In the interest of justice, detainees for 30 days and further detention must be considered for 90 days in the interest of justice, subject to the reasonable conditions, as the minister also has highlighted. The detainees are granted the right to challenge and or demonstrate lawfulness of their arrest and detention before a magistrate. These provisions collectively aim to comply with the Constitutional Court Directive and reaffirm South Africa's commitment to human rights and the rule of law. On the other hand, Honorable Speaker, we are mindful of the initiative as raised by Honorable Ramolobing, the Chair of the Correctional Service, during the budget vote to amend the Correctional Service Act Section 7, which talk to the length and form of the sentence of foreign nationals. The objective, as we understand, is for foreign nationals to serve the sentence in their country of origin, which will lessen the cost implication and overcrowding in our facilities. We, as the Portfolio Committee, will encourage Minister Schreiber to strengthen the engagement with Minister of Correctional Services on this subject matter. House Chairperson, also Speaker, as we highlighted earlier, the committee is resolute in its view that the Department of Home Affairs or the Minister and the Deputy Minister must expedite the finalization of the revised white paper on citizen immigration and refugee protection. This is critical to ensure that our immigration system remain legally sound, human rights compliant, aligned with international best practices. Yesterday debate demonstrated and reaffirmed our collective call for the Minister of Home Affairs to speed up the process of the bill to afford Parliament or this House and all South Africans to have a conversation about the subject matter. We tabled this report, which addresses constitutional shortcomings identified by the Constitutional Court to strengthen the integrity of our immigration system and uphold the values enshrined in the Constitution of the Republic for consideration for this House. Nakens.
Thank you, Honorable Member. Honorable MB Mohammed.
I greet you all in the universal greeting of peace. Assalamu alaikum wa rahmatullahi wa barakatuh. Honorable Speaker, the Immigration Amendment Act 8 of 2024 is being presented as a victory for justice. But let us not deceive ourselves. This act is not the product of foresight. It is the byproduct of court orders, a bill born in the courtroom, not in the conscience of Parliament. Yes, Section 34 is being amended. It now forces the state to bring a detained foreign national before a court within 48 hours. It limits detention to 30 days unless a judge rules otherwise. It also introduces judicial oversight, where once there was only bureaucratic power. But here is the truth. These reforms were not guided by government's moral compass. They were forced upon it. First by the Constitutional Court in Lawyers for Human Rights versus Minister of Home Affairs in 2017, and again in Ex parte Minister of Home Affairs in 2023. Twice our courts reminded this very government, justice delayed is dignity denied. Without those rulings, Parliament would not be debating this bill here today. Even now, the Department of Litigation, Department of Home Affairs, is collapsing under the weight of its own inefficiency. Minister Leon Schreiber, happy birthday. You preside over a department crippled by backlogs, broken IT systems and queues that stretch for miles. These failures are not minor hiccups. They are systemic. They are the very reason thousands of people become undocumented. People are not illegal because of their own choosing. They are undocumented because Home Affairs manufactures this chaos. Instead of confronting dysfunction, the bill still clings to the dehumanizing language of illegal foreigners. Words matter, Honorable Speaker. This language fuels xenophobia. It strips people of dignity, and it violates the spirit of our Constitution, which promises equality for all who live in South Africa. And what about the most vulnerable, the stateless, those who cannot be deported because no country will claim them? Those left in limbo, unable to access rights, unable to move forward. This bill offers them nothing but an endless cycle of detention and despair. There are people born in South Africa by undocumented foreign nationals who became stateless. This is because we do not have visionary laws that deal with such peculiar cases. Imagine trying to deport a minor who was born in South Africa, never been to another country. The only misfortune is that they have a mother who's Mozambican and a Congolese as a father. They are unable to obtain a birth certificate and ID document. It means they cannot go to university. Their future, because of lack of documentation, is bleak. A prison without walls, a sentence without end. Let us be clear. This amendment is not a bold step forward. It's a reactive half measure, a legislative bandage on a wound that demands surgery. Procrastination dressed up as progress. South Africa deserves an immigration system that is visionary, humane, and sovereign. A system that secures our border, yes, but also secures the dignity of every human being. A system that does not criminalize desperation, but confronts corruption. A system that does not scapegoat migrants for dysfunction, but holds the minister accountable for failure. So the MK party says directly to you, Minister Schreiber, fix your house before you criminalize the homeless. Fix your systems before you stigmatize the stateless. Fix Home Affairs before you lecture South Africans about immigration. Honorable Speaker, let it be known that the MK party will not sit quietly while South Africans suffer from failures of Home Affairs. We will not allow backlogs to become the border. We will not allow inefficiency to become the policy. We will fight for laws that are just, humane, and truly sovereign. Because immigration must never be about fear. Immigration must be about fairness. Immigration must never be about exclusion. Immigration must be about justice. Immigration must never be about headlines. Immigration should be about humanity. Until then, MK rejects the pretense of progress, and we demand justice, fairness, forward-thinking, and sovereignty. I thank you.
Thank you, Honorable Member. Honorable Member Rose.
Right. Thank you, Madam Speaker. This immigration amendment bill addresses defects in our immigration law that were declared unconstitutional in the 2017 Lawyers for Human Rights versus Minister of Home Affairs and others case. The bill intends to amend the constitutional defects of Section 34(1) of the Immigration Act of 2002, which prescribes the procedures for detention of an illegal foreigner before deportation. The bill aligns our immigration system with the Constitution, while giving the state stronger tools to enforce the law against illegal immigration. One of the most important aspects of this bill is the introduction of a clear interests of justice standard when dealing with the arrest and detention of illegal foreigners. Previously, too much discretion was left in the hands of immigration officers and magistrates. Decisions to detain or release were inconsistent, vulnerable to abuse, and often not subject to adequate oversight. That created two dangers. First, the risk of arbitrary detention, which the courts could not tolerate. And second, the risk of arbitrary release, which undermined the immigration enforcement and public confidence. This bill corrects that by requiring that the Minister of Home Affairs to set out regulations prescribing the factors that must be considered. Immigration officers and magistrates will no longer be guided by standard operating procedures that were not visible to magistrates nor detainees. They must apply the law against a set of clear and publicly available standards. Importantly, these interests of justice criteria do not weaken our hand against illegal immigration. In fact, the opposite, they strengthen it, because they ensure that every detention and every deportation stands up in court. It is costing South Africa 427 Rand per day to detain an illegal foreigner, and so it is important to prevent endless appeals and litigation that only delays deportations. The bill also restores proper judicial oversight. An illegal foreigner arrested for deportation must be informed of their rights in a language they understand where possible, brought before a court within 48 hours, detained only if a magistrate authorizes it, initially for 30 days and subject to further detention only if the court extends it for up to 90 days at a time. At each stage, the illegal foreigner has the right to make oral or written representations. This ensures that courts, not unchecked officials, make the final decision. By embedding these safeguards, we ensure that enforcement cannot be overturned on technicalities. We protect the integrity of the deportation process, making sure it is quick, lawful, and sustainable. Madam Speaker, let me turn to a group that deserves special mention, and that is children. Migration often hides a child's face. Children may arrive with families, or they may arrive alone. They may be victims of trafficking, or simply caught up in adult circumstances beyond their control. Our Constitution is unequivocal. In every matter concerning a child, the child's best interests are of paramount importance. The bill affirms that principle. It ensures that children are not simply processed as illegal foreigners, but dealt with under our child protection frameworks, particularly the Children's Act. What does this mean in practice? It means a child cannot be detained for immigration purposes except as a last resort, and only under judicial supervision. It means children must be referred to the appropriate child protection authorities, not locked up in facilities designed for adults. It means the Department of Home Affairs must cooperate with social services, the police, and the courts to ensure that children's safety and welfare comes first. We welcome the assurance from the State Law Advisor and the department that these protections are already being embedded in law and in practice. But vigilance is key. We cannot allow the rights of children to be lost in the shadows of immigration enforcement. And we also reiterate our call for the Portfolio Committee on Home Affairs to engage with the Department of Social Services on how they process the children of illegal foreigners, but also how they assist South African children in accessing their rightful documentation so that we defeat statelessness and ensure that each and every South African child enjoys the dignity of an identity and access to opportunity. House Chair, for far too long, undocumented foreigners have been able to enter and exit South Africa at will. And this bill is another step towards stronger implementation of the rule of law. This means being firm in enforcing the law unapologetically and firm in upholding the Constitution. Illegal immigration is not a minor inconvenience. It threatens our sovereignty, places heavy pressure on public services, undercuts employment for South Africans, and creates fertile ground for criminal syndicates. This is why the Department of Home Affairs, together with the Border Management Authority, has intensified enforcement efforts under the leadership of Minister Leon Schreiber. The progress in just over a year has been remarkable. In 24-25, 51,000 illegal immigrants were deported. That is an 18% increase on the previous year, the highest figure in at least 5 years, and that number is greater than the combined deportations of France and Germany in the same period. Immigration enforcement operations have surged from 383 to 1,415 in Q4 of 24-25. This nearly four-fold increase included extensive interventions to uphold the rule of law, dealing with zama-zamas and foodborne diseases in spaza shops. This increase in internal enforcement follows a 215% increase in the successful prevention of illegal border crossings in the 24-25 festive season, and a 63% increase in the successful prevention of illegal border crossings over the Easter period. The Border Management Authority continues to punch above its weight, thanks to the introduction of drones, artificial intelligence, and smart surveillance as part of Minister Schreiber's system modernization program. Operation New Broom, launched earlier this year, uses biometric technology to identify and prosecute illegal foreigners. Already in Pretoria's Plastic View settlement, 95 illegal immigrants were arrested. Similar operations are expanding. Now, these results show that enforcement is working, but without the constitutional fixes in this bill, many of these deportations could be challenged in court and overturned. And so by passing this bill, we are locking in those successes on a foundation of legality. Madam Speaker, the people of South Africa are rightly demanding action. They want to see their government take control of immigration, protect our borders, and uphold the law. This bill does exactly that. It ensures that immigration enforcement is constitutional, it protects the rights of children, it equips our officers and courts with the tools they need to deport illegal foreigners swiftly and lawfully. The Democratic Alliance supports this bill because in South Africa we believe that the rule of law is non-negotiable, that children must be protected and that illegal immigration must be confronted head-on so that we are not denied the benefits of lawful tourism into South Africa that will help grow the economy and create jobs. Thank you, Madam Speaker.
Thank you very much. Honorable Tembekwayo.
Honorable Speaker, the Economic Freedom Fighters supports the Immigration Amendment Bill. On the 29th of June 2017, the Constitutional Court in Lawyers for Human Rights versus Minister of Home Affairs and others declared sections 34(1)(b) and D of the Principal Act inconsistent with sections 12(1) and 35(2)(d) of the Constitution of the Republic of South Africa. The Constitutional Court found these sections unconstitutional because they denied the detainee the right to representation, and a detainee could be detained for much longer than 48 hours. Our actions must at all times be guided by the Constitution of the Republic and not by the xenophobic chants of fringe groups such as Dudula. Immigrants, whether legal or illegal, have a right to appear before a court of law and a right to be represented by a lawyer before the courts. These are rights that were denied to many Black people in South Africa under apartheid, and we dare not deny them to any human being, regardless of their status in the country. The challenges of illegal immigration into South Africa have been in the making for 20 years
because of the failure of successive ANC governments to secure the borders of South Africa. The Border Management Agency, which was created recently, is underfunded and does not have adequate resources to discharge their task. Large sections of our borders are not patrolled or monitored. And this has led to an influx of undocumented people coming into the country undetected. To successfully address the issue of illegal immigration, we need to capacitate the BMA, address the pull and push factors that contributes towards the inflow of undocumented migrants, such as regional instability, lack of economic growth, and South African employers who hire undocumented immigrants to sidestep labor laws. The high numbers of foreigners flocking into the country does not have to mean that we lower our basic stance of human dignity that must be afforded to all. The bill will ensure that illegal foreigners due for deportation are handled in a just and equitable manner, and that their rights to human dignity must be counterbalanced with the right of the South African state to maintain its territorial integrity. The bill, for instance, provides that an immigration officer may only arrest for deportation of an illegal foreigner after having thoroughly interviewed him or her to establish whether it would be in the interest of justice for that foreigner to be detained and deported. This provides for a law of general application on how to handle immigrants in a humane and legally logical way. We are in support of this bill. Thank you, Speaker.
Thank you, Dr. Tambekwayo. Honorable Van der Merwe.
Thank you very much, Honorable Speaker. And let me also join you in wishing the Honorable Minister a happy birthday. Feels geluk met jou verjaarsdag. I know he's a very young minister, so I'm not sure. I think he's turned 21 today. House Chairperson, or Speaker, on 18 September 2019, during a special sitting of this House, the President of the Republic, Mr. Cyril Ramaphosa, addressed us on two national emergencies: gender-based violence and the spiraling immigration crisis. Speaker, allow me therefore just 1 minute to quickly pause and clarify the misinformation that was peddled this week in the House when we as honourable members were unfairly blamed for not setting up the National Council on Gender-Based Violence and Femicide. Firstly, it's important to note that the act setting up the council was only proclaimed and came into effect on the 15th of November 2024, which is less than a year ago. And yes, while the 6 administrations portfolio committee could not finalize the work, so did the previous government do nothing by neglecting to allocate resources and by failing to nominate representatives from various departments to serve on this council. Moreover, we were told repeatedly that there was no budget for this council, no funds to pay civil society, and a plan for a bloated administrative structure. As a portfolio committee, we could simply not accept this, and we were not willing to set this council up for failure. And I thought it was just important to clarify that. But back to the issue at hand, during this special sitting of this House, the President said the following about our immigration crisis, and I quote, "We know that our people are concerned about illegal migration. We understand the concerns of local businesses struggling to compete against counterfeit goods. We share your frustration that some South African employers are employing foreign nationals over locals, turning workers against workers. Police and immigration officials who take bribes in return for making cases go away or for issuing fraudulent documents must be dealt with firmly. South African employers, be they in the trucking industry, hospitality, or agriculture, must obey the law. We should consider, as many other countries have done, the regulation of how foreign nationals can own and participate in certain types of businesses within the small and medium enterprise sector. And we must acknowledge that there are certain parts of the country where specific foreign nationals have been identified as the main dealers and peddlers of drugs. Those were the words of our Honourable President. Fast forward 6 years later, and nothing has changed. Honourable Minister, the crisis runs much deeper than just our non-existent borders. It is intertwined with systematic corruption within Home Affairs. Some migrants arrive at our borders without documentation, while many others carry fake IDs, fake passports, are in possession of fake study permits and other documentation such as asylum seeker documentation. It is really sometimes just a free-for-all. And you only have to have eyes to see the dire consequences on our communities. Industries like e-hailing, beauty, hospitality, delivery services, and our spaza shop industry is now increasingly dominated or run by foreign nationals. And yet when we raise these painful truths, those who have good jobs, those with medical aids, and those whose children are not on waiting lists at public schools, and those who benefit from employing illegal migrants are the first ones to dismiss South Africans' concerns as xenophobic. They have the luxury of ignoring the real harm inflicted on our nation. The Immigration Amendment Bill before us is a necessary correction mandated by the Concord, mandating that detained illegal foreigners be brought before a court within 48 hours, guided by the interests of justice principles. We support, as the IFP, the rule of law, and believe, therefore, that we must fix laws that violate the Constitution. We further welcome the steps that will ensure greater protection of children. But we must also acknowledge that many illegal migrants lack verifiable addresses or means to be traced or returned to court. This too carries a danger. And Minister, I heard you that we will now be able to execute legally compliant deportations, but this should not be needed in the first place. It is time for migrants to enter South Africa with proper documentation, including medical insurance, which is the case in other countries. In closing, the IFP will support this bill, but Honourable Minister, take South Africans' concerns seriously about illegal migration. We need broader reforms that put our citizens first, upholding the rule of law, protecting our sovereignty, and ensuring our resources benefit South Africans. I thank you.
Thank you, Honourable Member Van Merwe. I allowed you to finish your clarification, even though it was not an opportunity to do so in the debate. The Speaker was going to address that matter because it related to the processes of Parliament. I think next time, chairpersons must try and, even if they feel strongly about the issue, not to take an opportunity on other matters of national importance to address those concerns. I'll now ask Honourable Matopa.
Thank you, Honourable Speaker, honourable members. Today, the Patriotic Alliance stands in firm support of the Immigration Amendment Bill, Act B8 of 2024, tabled in response to the Constitutional Court's ruling in Lawyers for Human Rights versus Minister of Home Affairs. This bill is not merely a technical fix, it is a constitutional correction and a reaffirmation of our democratic values. For too long, the detention of undocumented foreign nationals operated in a legal vacuum, undermining both human dignity and the rule of law. This bill introduces critical safeguards, judicial oversight within 24 hours, access to legal representation, and defined limits on detention. These are not optional, they are the bare minimum required by our Constitution. But let us be unequivocal. Constitutional compliance must not come at the expense of our national sovereignty. The Patriotic Alliance has consistently warned against the consequences of porous borders and unchecked migration. Our communities, especially in townships and informal settlements, bear the brunt of overcrowded clinics, overburdened schools, and rising lawlessness. South Africans deserve a government that puts their safety, livelihoods, and dignity first. This bill is a step in the right direction. It restores legal clarity and operational discipline, but it must be followed by decisive action, strengthening border control infrastructure, fast-tracking deportation process for unlawful entrants, rooting out corruption within Home Affairs and law enforcement, establishing a transparent registry of foreign nationals in the informal economy. Within the GNU, we urge our partners to move beyond legal compliance and towards strategic reform. Immigration policy must serve the national interest, not ideological abstraction. We must protect South African families from the erosion of public order and economic opportunity. Speaker, we support this bill because it affirms our constitutional obligations while laying the groundwork for a more secure, sovereign South Africa. We will continue to champion policies that restore dignity to our people, order to our borders, and accountability to our institutions. Let it be known South Africa is a welcoming nation, but not a lawless one. Thank you.
Thank you, Honorable Van Staden.
Thank you, Speaker. Minister, van ons kant af ook veel geluk met die verjaarsdag en mag dit 'n geseënde jaar vir u wees. Honorable Speaker, it's important to take note that this bill seeks to address the two Constitutional Court judgments by amending Section 34(1) of the Principal Act. The amendment assures that any illegal foreigner detained under this section must be brought before court in person within 48 hours of its arrest. The court will then determine whether it is in the interest of justice to take further action or to order continued detention for the purpose of deportation. The Constitutional Court had ruled that Sections 34(1)(b) and (d) of the Immigration Act of 2002 were unconstitutional. Nou, alhoewel hierdie 'n probleem is wat eintlik veroorsaak is deur die vorige administrasie, sal daar wel moet gekyk moet word daarna om hierdie soort van prosesse bietjie vinniger af te handel, om gehoor te gee aan hierdie soort van uitsprake wat deur die howe gelewer word. Yesterday morning, the media reported that the Department of Home Affairs spent R180 million over the past 3 financial years on the deportation of illegal foreigners. During this period, over 130,000 individuals were deported. Dit was skrikwekkend om verder te verneem dat 468,000 mense sedert April 2023 probeer het om die land onwettig binne te kom. Die Departement van Korrektiewe Dienste het gedurende Februarie vanjaar aangedui dat daar meer as 26,000 buitelanders in Suid-Afrikaanse tronke is, wat die belastingbetaler R463 per dag per gevangene kos. Dit kom neer op R12 miljoen per dag en oor die R4 miljard per jaar. En meeste van hierdie gevangenes het die immigrasiewet oortree. Oorvol tronke en 'n grensbestuursowerheid wat nie oor 'n genoegsame begroting beskik om hul werk voldoende uit te voer om ons landsgrense te beskerm nie, is 'n groot probleem. Nie net moet ons probeer om onwettige immigrante vinnig en doeltreffend terug te stuur na hulle land van herkoms nie, maar daar moet ook sterk opgetree word teenoor korrupte amptenare. Indien wet en orde die norm in hierdie land was en dit voldoende toegepas word, sal ons nie probleme met wetstoepassing op ons landsgrense gehad het nie. Die tyd het aangebreek om terug te keer na voldoende wet en orde. The FF+ support. I thank you, Speaker.
Thank you, Honorable Ngobeni.
Thank you, Honorable Speaker. No nation survives open borders. South Africa's borders are not merely porous, they are being trampled. International syndicates and waves of undocumented migrants move freely, draining our clinics, our schools, and our already strained welfare system. A country that cannot control its borders cannot guarantee dignity or safety for its own citizens. Action SA stands strong for secure borders and the protection of our people. We want lawful borders and decisive enforcement. We refuse to pretend that a failing immigration system is acceptable. Yet also, we know that the Constitution, the highest law of this republic, demands that every person's basic rights be respected. The Constitutional Court ruled in 2017 that the old Immigration Act allowed detention without swift judicial oversight. This bill is Parliament's answer. It compels a court's appearance within 48 hours and a regular review of any extended detention. We want to make this very clear to this House that law without capacity is an empty promise. And so we sound our warning in this regard. If government adds more court appearances and procedural layers without building enforcement muscle, deportations will be slow, our courts will choke, and communities will be left exposed. Action SA will not support paper rights that weaken real security. We are asking that the playbook be rewritten, that the white paper on international migration is nearly a decade old and hopelessly out of step with today's migration procedures and cross-border crimes. We demand an urgent, transparent review because South Africa needs a modern immigration policy that unites constitutional safeguards with a relentless defense of our sovereignty. Rights and security are not opposites. We can uphold the Constitution while enforcing the law. We can protect vulnerable people without surrendering our nation. But that requires a Home Affairs Department with resources, with trained officers, and the political will to remove those who break our immigration laws. Honorable members and Honorable Speaker, South Africans want action. We do not want excuses anymore. We want strong borders, we want just laws and nothing else. Let us pass only legislation that strengthens enforcement, respects our Constitution, and demands a full rewrite of our outdated migration policy. That is how we will protect our people and our beloved Republic. Action SA conditionally supports this report. We thank you very much, Honorable Speaker.
Thank you very much, Reverend K.R.J. Mishra.
Happy birthday, Honorable Minister. Speaker, the African Christian Democratic Party welcomes the Portfolio Committee's report on the Immigration Amendment Bill tabled on the 22nd of July, 2025. Yet we remain vigilant in our scrutiny of its constitutional, ethical, and practical implications. This bill seeks to rectify long-standing constitutional defects in Section 34 of the Immigration Act of 2002, as declared by the Constitutional Court in Lawyers for Human Rights versus Minister of Home Affairs and others. The court found that the absence of automatic judicial oversight and personal appearance before a magistrate for detained foreign nationals violated Section 12(1) and Section 34(2)(d) of the Constitution. The proposed amendments now mandate court appearance within 48 hours and necessary safeguard against arbitrary detention. However, public hearings revealed deep concern over implementation capacity. The South African Human Rights Commission warned that the justice system may lack the infrastructure to uphold these timelines, risking further rights violations. The ACDP calls for independent oversight of detention centers, guaranteed legal representation for all detainees, special protections for minors, asylum seekers, and stateless persons, a clear framework for the interest of justice test to prevent subjective or prejudicial detention decisions. We affirm the need for humane, constitutionally sound immigration policy, one that balances national security with the dignity of every person in the country. Let this bill not be a procedural fix alone, but a moral recalibration of our immigration ethos. Yesterday, I received a WhatsApp message that reads as follows. Hey,
your time is going.
Let me really quick
Just summarize.
What happened yesterday in Pretoria will break your heart. A foreign pregnant lady in labor and crying for help was denied entry at the clinic gate by Dudula members. They told her she doesn't belong here. Instead of being helped, she was chased away. In her pain, she collapsed on the pavement outside. She screamed, she cried, begging for mercy, but still no one opened the doors. Instead of helping, many people stood around her, taking out phones and some recorded.
I'm sorry, your time is up.
Okay, ma'am. Thank you.
Thank you, Honorable Member. Honorable Nontenja. Honorable Nontenja, UDM. Honorable Ghana.
Minget Kensam from my stool. Honorable members, fellow South Africans, Minget Sungulala. It is not unreasonable, nor is it xenophobic, to insist that we know who is entering our country, from which country they are coming from, and for what purpose. This is what any sovereign state does. The moment you allow people and goods to cross your borders without proper knowledge and control, you are inviting instability. Today, we are debating the Immigration Amendment Bill at a time when tensions and temperatures are rising across South Africa on the issue of immigration. Let us be frank, our problem as a country is not the absence of laws. Our problem is the lack of implementation of the very same laws we already have. If immigration laws were applied consistently, firmly and fairly, South Africa will have controlled migration. The worst mistake we can make as members of this House is to bury our heads in the sand, to pretend not to hear, not to see, not to feel the frustrations of ordinary South Africans. These frustrations are real. They are expressed in communities where irregular immigration is visible, where laws are openly flouted, and where South Africans feel abandoned by the state. It is precisely when government does not enforce its own laws that movements like Operation Dudula gain momentum. They thrive in the vacuum left by state inaction. Honorable members, let me be clear. We support the movement of people. We support the right of people to enter South Africa, but they must do so through legal channels. We must make it easier for foreign nationals to enter and leave the country, but only legally. Equally, we must make it more difficult and indeed impossible for anyone to enter our country illegally. If our systems worked, the arrest and deportation of undocumented migrants will be a last resort and not the front line of enforcement. Let me repeat, it is not unreasonable, nor is it xenophobic, to insist that we know who is entering our country, from which country they are coming from, and for what purpose. We must also be honest. Not every cry from a South African on immigration is rooted in xenophobia. Many of these cries are about fairness, safety, and respect for the law. This bill must therefore be more than tightening words on a paper. It must be about a clear commitment to apply the law, to protect our borders, to respect human dignity, and to restore the confidence of South Africans in their parliament and their government.
The Honorable Maimane.
Good afternoon, honorable members and honorable speaker. Firstly and most crucially, we need to recognize without a shadow of a doubt that this debate about immigration should be ultimately that immigration does not begin domestically, it begins at your border. And therefore, as Bill 1 South Africa, I want to welcome this particular bill, but I want to do so conscious of the fact that we are in reality, we are dealing with politics that have engulfed the world, which are politics of scarcity rather than politics of abundance. They're politics where people recognize that failures of government in terms of their ability to provide jobs, to provide opportunity, have become easy enough to become scapegoating and blaming of another. It is indeed about politics of dispossession. It is about politics that say to ourselves, while we absolve government of responsibility, we can look at the foreigner, the other. Let's be fair, honorable members. Immigration is indeed a global problem. People move across borders. We have South African citizens who live elsewhere. The question that we must answer is how do we do so legally to secure the rights of those both who live within the country and those who are outside the country? What we must do is ensure that, particularly in the SADC region, we make it easier and more possible for citizens to be able to move so legally without having to turn the problem into one of how do we expatriate citizens out of this country. We should all be quick to say, whilst the needs of South Africans about healthcare, about jobs, and how we can capacitate the state to deliver on that, we can't blame the state failure on that on immigrants. It must pain all of us when people are turned away like pregnant women at hospitals just because they don't possess a South African passport, for us to stand back and condemn and simply celebrate when operations like Dudula, etc., kick people away. Finally, I want us to be clear that BOSA supports the stance of the issue of pro-legal immigration into the country. It is important that we build an Africa that is prosperous, that has borders that work. And to do so, the funding of the Border Management Authority becomes an absolute deficit. We cannot be sitting here with a BMA that has got 11,000, that has a need for 11,100 personnel, yet it's sitting at less. We can't sit here and not appropriate the 2.2 billion rands that is required for the BMA to work better, so it can provide thermal scanners, modern police technology, and proper resources. So I want us to work harder at saying, let us capacitate the Border Management Authority. Let us give it its necessary equipment. Let's make sure anyone who comes into the country does so legally. And so that ultimately, when we deal with the implementation of this law, we are dealing with people who have chosen to break our laws, and then we can kick them out. But ultimately, this issue is about us protecting our sovereignty, making sure our laws are applied, and hearing the
Thank
cries
you,
of citizens.
Honourable
I
Maimane.
thank you.
Your time has expired. Thank you. The ATM. No speaker. The Honourable Modise Mpia.
Thank you, Deputy Speaker. Honorable members, we participate in this debate on the Immigration Amendment Bill as the ANC to communicate our message of support and to urge the House to pass the bill. As indicated by the Chair of the Portfolio Committee on Home Affairs, the Immigration Amendment Bill is a technical bill that resulted from the judgment of the Constitutional Court. As the African National Congress, we appreciate that migration is part of human reality and it impacts on receiving countries in negative and positive ways. Negatives include social strife when citizens of a country feel that their rights and standard of living are being impacted on. Positives include the extent of which migration can lead to a brain and entrepreneurial gain for a country. Across the world, migration is on the increase and countries find different ways of responding. The challenge that our country faces with regard to migration is the whole issue of illegal migration. It has a negative impact on the socio-economy of our country as it puts pressure on planning and on service delivery. On the other hand, and importantly so, our people are concerned about the impact of illegal migration on the security of the country. We have to reiterate the point that South Africa is not a hostile destination for anyone who wishes to visit our country for various reasons, including tourism. However, we make a point that everyone who travels in and out of South Africa should do so with necessary traveling documents. Our country, as one of the biggest economies in Africa, will naturally attract migrants who wish to invest and find economic opportunities in our country. In the same vein, South Africans,
individually and as business people or companies, will expand their reach to other parts of the world, and in the main in Africa, as part of their business and career developments. We are dealing with migration not in the context of denying people the opportunity to visit our country, but to do so within the parameters of the law. The amendments in the bill are essentially about the need to protect the rights of those illegal migrants detained in our courts, to ensure that they enjoy the rights as enshrined in our Constitution. As the African National Congress, we have always understood the concerns of our people regarding illegal migration and the need to strengthen border management and control. And in this regard, the ANC-led government has established the Border Management Authority, and it has officially launched by the President in 2023. The BMA is aimed at coordinating the control and management of our borders. Since its inception, the BMA has successfully...
My apologies, Honourable Member. The podium, please just take your seat. Honourable members on the platform, please make sure that you are muted. This is interrupting the speaker at the podium. We've had 2 interruptions now. Please make sure it is muted. And also, Chief Whips, could you please also encourage your members or inform your members that they should have their phones or their devices muted. My apologies, Honourable Member, please proceed.
Since its inception, the Border Management Authority has successfully intercepted illegal migrants crossing the borders, as well as illegal goods that were intended to enter our country. We are aware that the BMA requires additional funding in terms of budget allocations to ensure that it operates to its optimal and is able to procure technological equipment that will serve as a force multiplier in the managing and controlling of the borders. Over the last 30 years, South Africa has seen waves of migration, and as the country opened its borders and adopted without reservations African Union and United Nations protocols on migration and refugees. It is important to note that South Africa's rate of migration, measured by the number of foreign-born persons, according to the 2022 census, stands at the low end at 3% of the national population, although others place it as high as 4.8 to 5%, which is above the global average. Further, that a key challenge in our migration policy has been increasing a number of undocumented migrants, which is illegal in both constitution and in law. This manifests itself negatively in the following ways that include pressures on South Africa's social wage, particularly on education and health system, but also social security and settlements. The competition for jobs in sectors such as hospitality, agriculture, domestic work, the competition in the informal economy in townships and villages, as well as the involvement in illegal mining. We have also witnessed incidents of fraud, inefficiencies, and corruption in the migration system. It is on this basis that we welcome the major review through the draft white paper to be followed by law on citizenship, immigration, and refugee to tackle contradictions in the system. While our commitment to these protocols remains unwavering, we, however, are of the view that there is a need for our country to make reservations to some of the articles of these protocols. The right to make reservations on these protocols is provided for in the Convention. Many countries, including on the continent of Africa, have signed the conventions with some reservations guided by their domestic realities and national interest. We remain committed to the white paper on citizenship, immigration, and refugee protection that seeks to overhaul the immigration system of the country. The intention is to replace the existing legislation and integrate it into one act. We are aware of the white paper that is before the Cabinet and undergoing the Cabinet processes. We are also encouraged by the fact that the Department of Home Affairs had revised its strategic plan and the annual performance plan to ensure that the white paper will be processed within this 7th Parliament without any further delays. Once again, as the African National Congress, we stand in support of the immigration bill that is intended to give effect to the Constitutional Court orders on the processing of detained illegal migrants by our courts. I thank you.
The Honorable Ismail Musa.
Thank you, Deputy Speaker. I seek protection in Satan with the Almighty. I greet you in the name of the Almighty, the most gracious, the most merciful, Honorable Minister and fellow humanitarians in South Africa. Honorable Minister, bills when applied and considered should first be in line with the most important fact and principle, which is human dignity. Most crimes perpetuate in home affairs where human dignity does not prevail. Al-Jamaa welcomes the amendments to the immigration bill, which will protect the rights of detained undocumented immigrants, especially where vulnerable groups such as women, children, and those who do not have access to legal assistance. Honorable Deputy Speaker, Al-Jamaa would like to express its horror and disgust at how human dignity was affected in Pretoria, where the incident where a foreign pregnant woman was refused her dignity. It's by time that the rights of undocumented immigrants be protected. Al-Jamaa's former member of parliament questioned the Minister of Home Affairs on the number of Israeli immigrants who arrived in South Africa since October 2023, which have applied for work and residence permits, and how many Palestinians, the victims of a genocide perpetrated by the Zionist Israeli entity, have been denied refugee status, residence, or work permits. The Honorable Minister has failed to respond to the questions previously asked by my predecessor, Advocate Shamima. Furthermore, many foreign residents living for years here in this country are deprived and struggling for years on end to sort documentation out. The minister needs to immediately solve this crisis. Until we don't jack up our services and systems, Home Affairs and the Home Affairs to understand the problems at grassroots levels, we will remain with mass problems of undocumented citizens. Respecting Constitution is respecting human dignity. Lastly, love has no bounds for humanity. We need answers from the minister. Why is it easier for apartheid and genocide supporters from Israel to immigrate to South Africa than for Palestinians and refugees from our own neighboring countries? Thank you.
The NCC. No speaker. PAC. No one. UAT. No one. Good. No speaker. Honorable Bowman.
Deputy House Chair, the Immigration Amendment Bill B8 of 2024 addresses constitutional defects that have lingered in our immigration law since the Constitutional Court's rulings in Lawyers for Human Rights versus the Minister for Home Affairs and others in 2017. That judgment found that Section 34(1) of the Immigration Act failed to protect the constitutional rights of detainees. Foreign nationals were being held without proper judicial oversight, without clear access to legal representation, and without the opportunity to challenge their detention in a court of law. This bill now corrects those defects, aligning immigration enforcement with the Constitution while strengthening the state's hand against illegal immigration. The bill embeds the guarantees contained in Section 35(2) of the Constitution. Every person
who is detained has the right to be told why, to consult a legal practitioner, and to challenge their detention before a court. These safeguards are not a concession. They are a reinforcement. They ensure that deportations are not overturned on technicalities, but stand firm because they are built on legality from the start. The bill also deals with the important matter of language. It requires that detainees are informed of their rights in a language they understand, where practicable and reasonably available. This strikes the right balance, dignity and fairness on the one hand, and practicality on the other. Without such a standard, enforcement could grind to a halt under frivolous challenges. With it, the system is both constitutional and workable. These reforms come at a time when the Department of Home Affairs under Minister Leon Schreiber is showing what capable leadership can achieve. During the Easter period, the Border Management Authority intercepted 6,253 illegal crossing attempts. That's a whopping 63% increase from the year before, supported by drones, AI, and smart surveillance. Operation New Broom, using biometric verification, has already produced results, with 95 arrests in the plastic leaf settlement and further operations rolling out across the country. These are not promises, but results. And by passing this bill, we lock those results into a framework that will withstand constitutional scrutiny and endure in the courts. Illegal immigration is not a minor concern. It places immense strain on our health system, on schools and housing, and on job opportunities for South Africans. It creates avenues for organized crime, and it undermines community stability. That is why this bill is necessary. By embedding Section 35(2), rights and reinforcing judicial oversight, we make sure that when enforcement takes place, it is swift, lawful, and defensible. We protect the state from endless appeals while upholding the dignity and rights of those affected. This bill avoids the extremes. It does not allow indefinite detention without oversight. It does not permit open borders without control. Instead, it charts a middle course, firm enforcement within the framework of the Constitution. The Democratic Alliance position is consistent. We stand for constitutionalism, accountable governance, and effective administration. We therefore support this bill because it ensures that immigration enforcement is not undermined by avoidable constitutional challenges. Instead, it provides a clear and lawful framework within which the department can act decisively and effectively. Honourable members, South Africans are asking for a government that can do two things at once: respect rights and uphold the law. This bill helps us do exactly that. It does not excuse failure. It removes excuses for failure. It ensures that when the state acts, it acts lawfully, efficiently, and with outcomes that hold. The Democratic Alliance will support this bill because it strengthens our immigration framework. It restores credibility to enforcement, and it protects the sovereignty of the Republic. And let us acknowledge, under Minister Leon Schreiber's leadership, Home Affairs is becoming a department that delivers measurable results. And that is why the DA contributes, that is what the DA contributes to this GNU, a demonstration that South Africa can govern with both strength and justice. We owe our country an immigration system that is clear, fair, and firm. This bill is a step in that direction. I thank you.
I now invite the Deputy Minister of Home Affairs.
Honorable House Chairperson, the Minister of Home Affairs, Dr. Schreiber, happy birthday. Chairperson of the Portfolio Committee on Home Affairs, Honorable Musa Chabane, honorable members, the bill we are debating here today seeks to address two Constitutional Court judgments by amending Section 34(1) of the Immigration Act of 2002 to ensure that any illegal foreigner detained under this section is brought before a court in person within 48 hours from the time of his or her arrest and detention. This allows for the courts to then determine whether it is in the interest of justice to order further detention for purposes of deportation. The bill introduces the interest of justice criterion, which will serve as a guidance within which immigration officers and other courts may exercise detention powers in respect of illegal foreigners. The Constitutional Court gave impetus to this legislation process, and thus the need for this process to be expedited, particularly for the benefit of immigration officers who are expected to enforce the Immigration Act without fear, favor, or prejudice. On the 29th of June 2017, the Court declared Section 34(1)(b) and (d) of the Immigration Act of 2002 inconsistent with Sections 12(1) and 35(2) of the Constitution of the Republic, and as such rendering them invalid. The declaration of invalidity was then suspended for a period of 24 months from the date of the order to enable Parliament to correct the defects in Section 34(1)(b) and (d) of the Immigration Act. The Constitutional Court ordered that pending the correction of the defects within 24 months, being 28 June 2019, and upon the expiry of this period, any illegal foreigner detained under Section 34(1) of the Immigration Act must be brought before the court in person within 48 hours. Some of the instructions that were given at Home Affairs were already implementing them as directed by the Constitutional Court. And I must indicate that over the past portfolio committees, they've been welcomed. Sometimes it's strange how people then tend to pivot when we're here. Since the period of the 24 months left, the processing of illegal foreign nationals for purposes of deportation in accordance with the remedy provided by the Court, which remedy continues to apply as I've indicated. Ours is a constitutional democracy, Chair, and as such, it is paramount for us to comply fully with the court's judgment. On the 30th of October 2023, the Court held that while it cannot revive statutory provisions after the expiry of the suspension period, it can, in terms of Section 1721(b) of the Constitution, order amplified, just and equitable relief to supplement the 2017 order. The Constitutional Court held that the 2017 order is not capable of interpretation, that it kept Section 34(1)(b) and (d) of the Immigration Act of 2002 alive in the event Parliament fails to enact remedial legislation. The Constitutional Court also found it appropriate to cure further constitutional defects in order, namely to provide.
Honourable Member, please mute your microphone. Honourable Member. Please proceed, Deputy Minister.
The Constitutional Court also found it appropriate to cure further constitutional defects in order, namely to provide for in-person appearances by a detainee when a court is considering whether to extend a detention beyond 30 days and to introduce the interest of justice criterion as guided for the exercise of detention powers by immigration officers in the court. The Constitutional Court further ordered that pending the enactment of remedial legislation within 12 months and in the relevant remedial legislation is not enacted within this period, the provisions listed in the order which supplement the 2017 order apply. These provisions was as such. An immigration officer must apply the interest of justice criterion when considering the arrest and detention of an illegal foreigner in terms of Section 34(1) of the Immigration Act of 2002. A detained person shall be brought before the court within 48 hours from the time of arrest. The court must apply the interest of justice criterion when the arrested person is brought before the court. The court may authorize the further detention of the person concerned if it concludes that it's not in the interest of justice to permit the person's release. If the further detention of the person concerned is ordered, she must apply to be brought before the court prior to the expiry of the authorized detention period. And the court must again apply the interest of justice criterion at that stage. The court may then again authorize further detention of this person by no more than 90 calendar days if it concludes that the interests of justice do not permit the person release. Whenever the person concerned is brought before the court, he or she must be given an opportunity to make representations to the court as per the Constitution dictates. Parliament is a supreme legislative authority in the Republic. It bears the constitutional responsibility to enact, amend, and oversee legislation in a manner that gives effect to the values and principles of the Constitution. And as Parliament, we must always hold true to that. In fulfilling its mandate, Parliament must also respond to judicial pronouncements that identify constitutional deficiencies in existing laws. The recent directive of the Constitutional Court with respect to the immigration bill underscores the imperative of legislative alignment with constitutional standards. It is therefore incumbent upon us as Parliament to amend the bill as directed, not only to ensure compliance with the court's ruling, but also to safeguard the integrity of the legislative process, uphold the separation of powers, and guarantee that the rights and obligations arising from immigration law are administered within a constitutionally sound framework. The Immigration Amendment Bill before us here today strengthens the legal framework for the arrest, detention, and deportation of illegal foreigners, which is beneficial for the operations of the Border Management Authority. Currently, the BMA relies on the cooperation and relations that are created with partners in law enforcement, mainly within the border law enforcement area and the courts situated within close proximity of the area. Now, this bill, by introducing the interest of justice criterion, provides immigration officers on the ground with clear and defensible procedures to be followed in detaining illegal foreign nationals, thus providing legal safeguards for the authority in executing its mandate and in insurance in compliance with human rights. Indeed, our border law enforcement officials will have more powers and more teeth to bite through this legislation. Operationally, the enactment of the bill will see enhanced stakeholder coordination amongst BMA, Home Affairs, SAPS, and the National Prosecuting Authority. This clarifies in law will strengthen participation in the case flow management within the border law enforcement area, commonly chaired by the magistrates, where the parties, which includes port commanders, commonly chaired by magistrates, will now monitor consistent application of the criterion in the interest of securing our borders. It becomes a tool to be used in our border environment to protect our borders. The Department of Home Affairs bears the constitutional and legislative mandate to ensure immigration is properly regulated and results in economic development, economic border management, refugee protection, peace and stability, and respect for the rule of law by all in our land with no exceptions. Therefore, the work towards the conclusion of this bill is very important for the Department of Home Affairs, wherein we are currently making inroads in improving the management of international migration, upholding the rule of law. While work on South Africa's policy on citizenship, immigration, and refugee protection is apace, it is important to see deliberations on the Immigration Amendment Bill drawing closer to the conclusion. They take us further. Getting clarity on these issues, particularly on the vexed issue of illegal immigration and the ramification, should be of utmost importance to all who love our country and its people. Any uncertainty has a potential to hamper the work of immigration officers in enforcing the Immigration Act and ensuring all in our country are safe and feel safe, with no one roaming the streets undocumented or illegally in any other way. When all has been said and done, we've got to decisively address the risk of foreigners entering our country illegally and not doing right by our country. This cannot be accepted by any South African, and this bill takes us closer to ensuring that happens. We are dedicating resources to enforcing the rule of law, but when immigration officers apprehend illegal foreigners through technologically enhanced operations that the department is carrying out, they should harbor no doubt that their work might at some point be in vain, that there is clarity now on laws and how these matters are to be handled. We will indeed continue to see benefits of the technological advancement we are making within our border environment. Concluding this bill, Chair, will give South Africa objectively determinable conditions and guidance for how to exercise the power to detain in line with the Constitution. Through legislation, we are finally laying to rest and giving certainty to issues which will have been handled at an administrative level. Today, we are moving closer towards giving the state the legislative tools that will enable it to take further its fight against illegal immigration. I thank you.
The Honourable Minister of Home Affairs.
Thank you, Deputy Speaker. I must say, they say you need to be prepared for all situations, but the serenade from the Speaker I was not prepared for. And thank you very much to the colleagues for the kind birthday wishes as well. Deputy Speaker, let me just put to rest concern about the impact of this amendment. We have an unusual situation here in the sense that we've already been working under this system for a number of years. In the most recent financial year, over 51,000 deportations reported by the department. That's more than France and Germany combined, and it is already under the system that we've spoken about here today. The big challenge we've been having is the uncertainty that the Deputy Minister alludes to as well. And this amendment is going to clarify that. So the reality is that we can see from the numbers that there's nothing holding us back from effective enforcement through this amendment. In fact, we will have more certainty and clarity in our ability to carry out that mandate. I think, Deputy Speaker, a lot of the debate has obviously focused on broader issues, and I think it's important to acknowledge those. What I would say is that equally, the country is tired of complaints about this issue. So we need to move from simply complaining and saying there's a problem, and we need to move to the implementation of solutions. And I think a lot of members here have spoken about systems. You've used the word systems at Home Affairs. That is exactly what we are focused on, Deputy Speaker, systemic reform. Essentially, I think the Home Affairs ecosystem is telling you that we are ready to go, honourable members. We've spoken about the BMA modernization plan. We've spoken about the success that we've already demonstrated at a very limited scale. The implementation of the electronic travel authorization, Honourable van der Merwe, it's going to remove the papers. That's the whole point. We don't want fake documents. We want secure digital systems. That is not something happening long in the future. It's within the next few weeks that the ETA will be launching. There's references to identity theft, the green ID book, the vulnerabilities of that. We are expanding massively access to smart IDs through our expansion of the existing partnership with banks through technology again, bringing that to banking apps and really eliminating the risk that the green ID book poses. So, Deputy Speaker and honourable members, the broader debate that you are having, the solutions to that, not the complaints, the solutions are what matters. They are on the table very firmly. We are moving in that direction and we are ready to go. But I actually put the challenge back to honourable members. It is Parliament that appropriates, as the Honourable Maimane reminds us. It is Parliament that can address the 2.3 billion rand shortfall at the BMA. It is Parliament that can support work and the clear intention to reform the very systems that Parliament is complaining about. So the challenge is with you, honourable members. The MTBPS is coming up. The budget cycle is coming up. Let us work together to support initiatives that will address a problem that all of us are concerned about. Thank you very much.
Thank you, Honourable Minister. That then concludes the debate. Are there any objections to the Immigration Amendment Bill being read a second time? Honourable Douglas.
MK objects.
The MK's objection is noted. Honourable Beasley. Honourable Beasley.
Action SA objects, Chair.
The objection of Action SA is noted. Honourable members, order. With those objections noted, it is agreed to. The Secretary will read the bill a second time.
Immigration Amendment Bill.
The bill will be sent to the National Council of Provinces for concurrence. The Secretary will now read the third order.
Consideration of report of Portfolio Committee on Agriculture on Oversight visit to Perishable Products Export Control Board and Agricultural Research Council Stellenbosch Campus, Western Cape Province on 25 and 26 March 2025.
I now invite the Honourable Pule.
Thank you very much, Deputy Speaker, honorable members, fellow South Africans. I rise to present the oversight report of the Portfolio Committee on Agriculture on our visit to the Perishable Products Export Control Board, otherwise known as PPECB, and the Agricultural Research Council, ARC, Stellenbosch campus on the 25th and the 26th of March 2025. Parliament's constitutional mandate of oversight frames this report. Section 55, subsection 2 of the Constitution obliges the National Assembly to hold the executive accountable and maintain oversight of its actions. Portfolio committees fulfill this mandate through tools such as site visits and hearings. Recognizing that briefings alone are sometimes insufficient, the committee undertook this visit to observe operations firsthand. The two-day oversight visit aimed to deepen our understanding of two key entities under the Department of Agriculture. We sought insight into the operations and challenges of the PPECB and of the ARC Stellenbosch Research Campus. In particular, the committee examined how the PPECB regulates and facilitates South Africa's perishable exports, and how the ARC's fruit and wine research contributes to those industries so that Parliament can better support and oversee their work. On March 2025, the committee visited the PPECB's facilities in Cape Town. At the port and cold storage, we observed inspectors certifying the quality of export-bound fruit and maintaining proper cold chain conditions, underscoring the PPECB's vital role. Indeed, no perishable goods may be exported without the PPECB certificate. We were encouraged by the PPECB efforts to modernize its systems and to train emerging farmers. We also noted challenges, including infrastructure bottlenecks and weather-related disruptions at ports, as well as global market volatility. Addressing these issues will require ongoing cooperation across government, and we urge attention to these matters. On the 26th March, the committee engaged with the ARC at its Infrutech Nitfo Bay campus in Stellenbosch. Touring the laboratories and experimental farms, we were impressed by the ARC's contributions. For an example, improved fruit cultivars and wine yeast strains that bolster South Africa's fruit and wine industries. However, we were concerned to learn of serious resources constraints. The ARC's budget has been cut by almost 30% since 2016. Straining its ability to retain experts and upgrade equipment. Despite these challenges, ARC scientists remain dedicated and continue to produce excellent research. The committee believes that greater investment in agricultural research and innovation is essential. We urge the Department of National Treasury to prioritize support for the ARC so that its vital work can continue. In acknowledgement, I want to take this opportunity to thank the department representatives. including the Director General's office, who accompanied us, as well as the PPECB and ARC leadership and staff for their support and cooperation during the visit. We also acknowledge the contributions of all committee members in attendance. Honorable Deputy Speaker, this oversight visit has reinforced Parliament's insight into the achievements and challenges of the PPECB and ARC. We are confident that the report's findings and recommendations will help strengthen these entities and enhance accountability. Allow me, Honorable Deputy Speaker, to table the committee's report and respectfully request that the House adopts it. I thank you.
Thank you, Honorable Pule. I will now recognize political parties wishing to make a declaration. The usual times for declaration of votes will apply. The DA.
Thank you, Honourable Deputy Speaker. South Africa's agricultural export sector is one of the few shining lights in our economy. Our citrus, grapes, wines, and many other perishable products are recognized worldwide for their quality. However, for it to be successful, this industry depends on functioning state institutions, efficient logistics, and investment in science. What the committee observed is an industry shackled by previous ANC government failures that led to underfunded research and an inability to act decisively on trade and infrastructure requirements. The report on the challenges facing the PPECB and the ARC is very clear to see. Let us begin with the PPECB. This body is the backbone of our agricultural export credibility. Without these inspections and certifications, our products would not reach foreign markets, yet it faces crippling challenges. Firstly, the lack of investment in rail, road, and rural infrastructure are hampering exports, with many farmers, large and small, being locked out of export opportunities simply because they cannot get their produce to market. Secondly, the conditions at our ports are disastrous. It's ranked amongst the worst in the world. Perishable goods cannot sit idle for days. Delays means lost revenue, lost jobs, and lost in confidence from buyers. The truth is, Madam Deputy Speaker, that the state cannot fix this on its own. Private concessions to operate harbors and freight rail are essential to fix this. Around the world, private operators bring capital, efficiency, and accountability into port and rail management. Whilst here at home, Transnet has collapsed under mismanagement, corruption, and inefficiency. The DA has long argued that opening these networks to private participation is the only realistic path to restoring competitiveness. Agriculture, perhaps more than any other industry, stands to benefit from this the most. Another challenge is the negative impact that geopolitical disputes and trade barriers have on access to markets. In overcoming this challenge, the Minister of Agriculture, John Steenhuisen, has put in a lot of efforts to expand market access for our agricultural products. His work to negotiate entry into new markets and to expand existing markets is vital for growth in the agricultural sector, and it deserves our full support. Turning to the ARC, the work at Infotech Nuutvoorby in Stellenbosch, which we visited, shows what South Africa can achieve when science is prioritized. Research and development are not luxuries, they are necessities, and this must be realized by our provinces and other institutions. It will be to the benefit of our farmers if provincial departments will do more to increase the uptake and utilization of the ARC's research output and technological innovations. Further to this, the ARC has an agreement with the Land Bank to provide technical expertise in the blended finance scheme program. But this service is not being utilized by the Land Bank. This must change. If we want to grow our agricultural sector and create jobs, we must improve our infrastructure and invest in local innovation. This will require political will from the whole of government, and in this regard, we want to urge the Minister of Agriculture to continue with these engagements with the Minister of Transport to resolve the crisis at our ports and rails by opening the door for private concessions that can deliver efficiency where previous ANC governments have failed. We also request that the Minister must continue his engagements with the Minister of Finance to ensure that sufficient funding is provided to ensure that the ARC is properly funded, supported and modernized. South Africa's agricultural sector has got the talent. We have got the products and the potential. It has the power to create jobs, drive exports, and secure our food future, but only if government does its job as well by embracing partnerships with the private sector. Our farmers, our researchers, and our economy cannot wait. Therefore, the Democratic Alliance will continue to fight for reforms, investment, and accountability, including private concessions in ports and rail that will allow South Africa's agricultural industry to flourish as a cornerstone of growth and opportunity for all South Africans. The Democratic Alliance supports this report. I thank you.
The MK.
Thank you. The first South African Department of Agriculture was established by the Cape Colony in 1889. Its main objective was to serve white agriculture. This objective still drives the Department of Agriculture to this day. The ANC has actually surrendered the Department of Agriculture to the white leadership of the Democratic Alliance. We are back to 1948 when apartheid was officially adopted. White agriculture dominates the sector and therefore services provided by the department benefits white agriculture mostly. The Perishable Products Export Control Board serves white agriculture. Government provides legislative legitimation to facilitate exports. The agricultural sector is geared to serving the export market when the domestic market suffers acute food insecurity. As a result of this and the abolishing of agricultural market boards, which regulated supply and demand and therefore pricing, the price of food has skyrocketed and it is now determined by supermarkets whose only motive is profit. With the GNU, we are reverting back to 1948. We cannot expect that the needs of the suffering black majority of our people will be catered for. In this country, 15 million people experience food insecurity. 6.8 million suffer acute food insecurity. Yet the industry destroys large quantities of food annually in service of profits before people. The sector is racist, as it is unpatriotic, and it is cruel. The symbol of white agriculture is violence. How can we forget the story of the Limpopo farmers who murdered 2 black women and fed their bodies to their pigs? These farmers, if they are exporting their produce, they will be assisted by the Department of Agriculture through the PPECB. Among the services provided by the Perishable Products Export Control Board is the Food Safety Certification. This is in a country white farmers motivated by profits had to be compelled after the death of children by cabinet to stop using this killer pesticide known as Tabaphos. The Perishable Products Export Control Board had folded when confronted by an agricultural sector which does not want to transform. Quickly, it retreated when it tried to enforce BBEE compliance by the agricultural sector. It leaves farmers to their own devices and therefore the sector self-regulates. Umkhonto weSizwe government shall transform the agricultural sector to put people before profits and address national food security before exports.
Entities like the Perishable Products Export Board shall have their mandates focus on serving South Africa first before export markets. Only a transformative farmers certified to export, and only after they have met their domestic quotas. We put the people of South Africa first. And, you know, just 2 days ago, a farmer in the Free State, Kroonstad, Dr. Trotsky,
Thank you,
was
Honourable
in
Member.
court
Your
for killing
time has
black farmers.
expired.
What?
The EFF.
Thank you very much, Chairperson. My colleagues, Honourable Montweri, attended these oversight visits and has shared great insight about what he observed during the visits to both the Perishable Product Export Board and the Agricultural Research Council. Both these institutions are crucial for development of our agricultural industry. And some of the concerns we have with them may be a product of the broader policy framework within which they operate. We are, for instance, gravely concerned that while the PPECB safeguard the integrity of our agricultural exports, only 5% of these exports are meant for African markets, with the rest going to Europe and the USA. This limits the true scope and reach of our agricultural industry, but that is a policy issue that this Parliament and the Executive need to address. As a result of the above, the PPECB is only focused on established farmers who are their members, and they are not doing enough to partner with the Department of Agriculture and create offtakes for smallholder farmers involved in the sector by buying their products. This is unlikely to change considering the conservative right-wing minister we have at the moment. Emerging Black farmers will continue being on their own without the threat of help from the state, while the settler communities continue to benefit. Similarly, for the Agricultural Research Council, the ARC has been unable to break the barriers created by apartheid and ensure that the research found expression in the manner emerging farmers conduct their farming. The ARC is making cultivars for a variety of seeds, but these seeds are not entering the emerging farmers market because of stringent controls over seed by monopolies, and the department has not done anything to intervene. The department is delaying the finalization, the commercialization of the ARC because they know how will that affect big businesses controlling the GNU. A lot of government farmers and communal arable land remains fallow because government doesn't have money to plant for farmers. ARC should be producing seeds and supplying to communities to plant and part contributing to a food secure country, and therefore the economic freedom fighters reject this report. Thank you.
The IFP.
Thank you, Madam Deputy Speaker. The oversight demonstrated that both institutions are indispensable to South Africa's agricultural competitiveness. The Perishable Product Export Control Board, as the sole certifier of perishable exports, underpins international's confidence in our products. Yet the committee's engagements laid bare infrastructure constraints at ports, high costs of market access, and barrier to African and Asian export growth. These challenges directly undermine smallholder and emerging black farmers, who, despite training, often struggle to secure reliable export markets. The Agricultural Research Council, on the other hand, remains the backbone of agricultural research and innovation, developing plant varieties, advancing crop and wine sciences, and contributing to food security. But the persistent underfunding of the ARCs since 2016 has severely constrained its capacity. If research is not adequately funded, our agricultural sector will fall behind in innovation, sustainability, and agro-processing opportunities. The future of our agricultural exports, rural transformation, and food security depend on bold action, not complacency. In consideration of what we have raised, the IFP supports the reports. I thank you.
The PA.
We, the Patriotic Alliance, hereby declare our support for the report under consideration. We fully acknowledge that the Agriculture Committee is a government entity, and as such, it is not intended to generate profit. However, it is unreasonable to expect any entity to perform at its full potential when its budget is consistently subjected to cuts. South Africa has a rich and proud agricultural history. And it is vital that we recognize the significance of our agricultural exports to the nation's economy and global standing. The Agricultural Research Committee in particular fulfills a crucial mandate, safeguarding natural resources, promoting agricultural industries, developing and transferring technology, and conducting critical research into climate change and its impact on agriculture, amongst other responsibilities. Budgetary constraints severely hinder the effectiveness of these entities, ultimately weakening both the sector and the broader economy. We therefore call upon the Honourable Minister to urgently address this matter and to develop sustainable and effective solutions that will allow our agricultural institutions to thrive, ensuring food security, economic stability, and continued growth for our nation. I would also like to congratulate the Patriotic Alliance on winning Ward 1 in Kokama, Eastern Cape. Thank you.
The Freedom Front Plus.
Agbare Adjunkspreker, so 50 jaar gelede het die ANC sy beste gedoen om Suid-Afrika se ekonomie op sy knie te bring met sanksies en boikotte. Fondasie van die stryd daarteen was die landbou gewees wat met die beste produkte op die wêreldmark moes kompeteer. En in daardie stryd het die PPECB en die LNR 'n sentrale rol gespeel. Suid-Afrika moes eenvoudig die beste produkte op die rakke hê in Engeland en in Europa sodat niemand kon weier om die produkte te koop nie. My eerste werk waarvoor ek 'n salaris gekry het was by die tafeldruiwe koelkamer in Nylstroom in 1992. Ek moes daai druiwe deurkyk en dit kyk uit die oogpunt van 'n PPECB inspekteur sodat ons liewers na die binnelandse mark kan stuur wat nie geskik gaan wees vir buitelands nie. En dit is inderdaad nogal nie 'n maklike saak vir enige boer om aan daardie standaarde te voldoen nie. Nou, as ons 50 jaar later kyk, dan doen die PPECB en die LNR nog altyd sy bes om hierdie werk te doen. Ek kan miskien net sê die PPECB het dalk amptelike Afrikaanse naam, maar ek nog nooit gehoor dat iemand dit gebruik nie. Niet voorby en Infrotech wat nog steeds cultivars ontwikkel, wat bestand is teen siektes, wat grondgedraagde siektes kan oorleef, maar begrotingstekorte wat die LNR tuister en die PPECB wat deur die hopelose logistieke gebreke in Suid-Afrika gerem word, wat maak dat hulle werk nie doeltreffend kan doen nie. Dit alles bring mense ver om te sê my maggies, daar's 'n makliker manier om die ekonomie op sy
Action essay.
Speaker, this report lays bare two truths about agriculture in South Africa. First, we have world-class institutions like the PBECB and the ARC doing vital work to keep our exports trusted and our research competitive. However, the second truth highlights that these very institutions are being undermined by poor governance, crumbling infrastructure, and shrinking budgets. The PPECB stands at the gatekeeper of quality, ensuring that our fruits, vegetables, and perishables meet the strictest global standards. Yet, even when our produce passes the highest quality standards, our farmers face tariff and non-tariff barriers in key export markets. These barriers make it harder for South Africans' produce to compete globally. And when combined with the inefficiencies at our ports, they effectively price smallholder and emerging farmers out of international trade. If government is serious about supporting agriculture, it must negotiate fairer tariff conditions abroad and ensure that our exporters are not penalized because of failures at home. The ARC Stellenbosch campus, through decades of innovation in fruit, wine, and agro-processing research, remains the backbone of scientific advancement in agriculture. From yeast development for winemaking to climate-resilient cultivars, the ARC has consistently produced world-class innovations. However, chronic underfunding and severe budget cuts threaten its mandate, risking the erosion of research capacity, essentially for food security, farmer support, and transformation of the agriculture sector. This report rightly calls on government to fast-track the review of both the PPECB and ARC Acts to strengthen funding and to ensure better coordination between national and provincial departments. The recommendations also highlight the urgent need for investment. Speaker, the report deserves our support as it points to solutions that can strengthen agriculture, empower smallholders, and safeguard our position in global markets. I thank you.
The ACDP.
Madam Deputy Speaker, the ACDP supports the report. Thank you.
Thank you. UDM. Rise. Orsa. ATM. Al-Jamar. NCC. PAC. Slim pickings today. UAT.
Thank you, Deputy Speaker. Khotso, Ma-Afrika. The PPECB ensure that our exports reach global shelves, yet our African smallholder farmers remain largely excluded from the export chain. Training alone will not liberate them. What is the use of teaching a farmer to grow the best fruit if they have no access to the ports, the cold storage, or the export agents who control the markets? The true empowerment must be ownership and control. The ARC has given South Africa a world-class cultivars, yeast, and research, yet is starved of funding, trapped by outdated legislation, and stripped of its ability to commercialize its own innovations. Honorable members, this is how nation kill its own scientific sovereignty, by forcing its brightest institution to beg, while private capital profit from their labor. It is precisely these ports and trade routes that makes the imperialists dream of a new schemes, whispering about the so-called Cape exits, as they once gave Africa at the Berlin Conference. The struggle for our resources and our sovereignty is not history, it is happening now. This is not just an agricultural issue, it's a Pan-African question of sovereignty and dignity. As long as South Africa exports raw product and imports value-added goods, we remain trapped in a colonial economy. Chairperson, the spirit of Ubuntu demands more. Oversight must not be a passive observation. It must be an active transformation. We must fund ARC properly, legislate for its benefit from its own innovations, and impose transformation quotas in the PPECB
Thank you, Honourable
so that the
Member.
children
Your time has
of farmers can export themselves. Let us
Thank you, Honourable
let
Member. Your
oversight
time
serve
has
the people.
expired.
Let agriculture serve the nation, and let
Honourable Mr.
science serve
Lakwe.
Africa. Cut me, mambo.
Good. Not present. ANC.
Honorable Deputy Speaker, honorable members, South Africa citizens, I rise to support the adoption of the Portfolio Committee's oversight report on our visit to the Perishable Product Export Control Board and the Agricultural Research Council in Stellenbosch. This report follows our recent engagement with these entities, a key exercise of Parliament's constitutional duty to ensure executive accountability. In consideration this report, we reaffirm our commitment to oversight and to advancing the ANC's agenda of transformation and inclusive development in agriculture. At the PPECB, we observe its critical role in ensuring the quality of South Africa's agricultural exports. The PPECB's inspectors guarantee that our fruits, wines, and other perishable meet world-class standards, underpinning international confidence in our products. However, we also noted challenges: inadequate port and rail infrastructure, causing costly delays for farmers, and international trade barriers that limit export growth. Moreover, parts of the agricultural export value chain remain untransformed. Emerging black farmers and exporters face obstacles in accessing packhouses and markets. We commend the PPECB's effort to train smallholders and youth to export readiness, but these initiatives need greater support to truly empower new entrants. Accordingly, our report calls for swift coordination action to support the PPECB and our export sector. We urge the Minister of Agriculture to liaise with the Transnet and other departments to improve port and rail logistics, and to engage international partners to remove impediments to South Africans' export. We further recommend additional funding for the PPECB to expand its capacity buildings program for smallholders and the agri-export. These steps will help open the export industry to broader participation, enhance efficiency. At the ARC at Stellenbosch campus, we were inspired by the institution's cutting-edge research and innovation. The ARC remains the principal agricultural science institution in our country, and despite financial constraints, it continues to deliver world-class innovations. However, the committee was alarmed by the severe underfunding of the ARC, which had curtailed in critical work. To realize the National Development Plan's vision for a thriving, inclusive rural economy, we must reinvest in agricultural R&D and agro-processing to add value locally. We also noted that the many ARC innovations are not reaching our farmers, especially our small-scale farmers, due to weak extension support. We need to bridge the gap so that smallholders directly benefit from scientific breakthroughs. The ARC research outputs for farmers. We need the department to help the provincial governments to make sure that the small-scale farmers get every research that the ARC is doing. We also support the expenditure review of the ARC Act to increase the entity's agility, including empowering the ARC to establish a commercial arm to drive innovation and uptake and generate extra revenue. These measures will bolster the ARC's sustainability, contributing to the agricultural transformation. As Parliament, we will assist on accountability for these interventions. The Minister of Agriculture is expected to report back to the National Assembly within 2 months on progress in implementing our recommendations. This underscores our determination that oversight leads to real change. Honourable members, this report thus aligns with the ANC values and vision. The Freedom Charter declares that the land shall be shared amongst those who work it. Okker. The land shall be shared amongst those who work it. Okker. By empowering the smallholder and black farmers to access markets and resources, we are giving life to that ideal. The National Development Plan envisions vibrant, equitable, sustainable rural communities for food security for all, not certain people, food security for all. Through the recommendation in this report, we are taking concrete steps towards the vision, promoting innovation, inclusive growth, and empowerment. In conclusion, I urge the House to adopt the oversight report and support its swift implementation. By improving infrastructure, investing in research, and empowering emerging farmers, we will drive rural development, create jobs, and ensuring food security. This declaration is grounded on our oversight mandate and our commitment to service delivery. Let us work together. Let us work together, members of Parliament. Yes, let us work together to build a transformed and inclusive agricultural sector that leaves no one behind. Amandla.
Thank you, Honourable Member. I now recognise the Honourable Chief Whip.
Thank you, Honourable House, Honourable Deputy Speaker. I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? Honourable Douglas.
Please note the objections of Mkhonto Wesizwe. Thank you.
The MK objection is noted. And with that objection, the motion is adopted. Secretary will now read the fourth order.
Consideration of report of Standing Committee on Auditor-General. On Auditor-General's letter in terms of section 126 sub 4 and 133 sub 2 sub B of Municipal Financial Management Act number 56 of 2003.
I now invite the Honourable Wessels.
Thank you, Honourable Deputy Speaker. Deputy Speaker, this report is about the delays in finalising the regulatory audits of municipalities and municipal entities. The delays are caused by certain municipalities not submitting their annual financial statements within the prescribed 3-month period, some municipalities not submitting financial statements at all. The Auditor-General of South Africa submitted a report to the Speaker of the National Assembly to inform Parliament of these delays and to request the Speaker to refer the report to relevant committees for consideration and further action. Amongst these committees, the report was referred to the Standing Committee on the Auditor-General. The committee deliberated on this report and received an in-depth briefing by the AGSA on this matter. It is important to note, Honourable Deputy Speaker, that the late submission or non-submission of financial statements not only constitutes non-compliance with the MFMA, but also adversely affects financial accountability, governance, and service delivery. It disrupts the accountability cycle by delaying audits and audit reporting, thus compromising transparency and effective decision-making. It also forces the AGSA to reallocate resources intended for provincial and national audits, thus creating operational pressures. Delays in audits undermine municipalities' performance in terms of their ability to effectively plan, budget, and deliver critical services, thus negatively impacting the lives of our citizens. it reduces accountability and transparency and thereby undermines trust and weakens public oversight. Persistent non-compliance impacts institutional integrity and points to weak governance structures and inadequate internal controls. This non-compliance is a symptom of the very dire state of local government, and the question must be asked, is this non-compliance, thus the poor financial record keeping and inability to prepare and submit financial statements, as a result of incompetence, or is it deliberate? Is it deliberate to avoid accountability? If one reflects on the list of non-compliant municipalities, and especially the repeat offenders in this regard, it is clear that there is a correlation between this non-compliance and extremely poor service delivery. The AGSA has appealed to Parliament to activate its powers to assist in addressing these ongoing challenges in order to strengthen oversight and improve financial accountability, governance, and service delivery in municipalities. These delays and this non-compliance is, at the end of the day, adversely affecting the execution of the mandate of the AGSA. There should be severe consequences for accounting officers who are responsible for these delays and non-submissions. The committee will, together with the Portfolio Committee on Cooperative Governance and Traditional Affairs, the Standing Committee on Public Accounts, and the Standing Committee on Finance, and in line with our individual mandates, interrogate the concerns identified, their impact, and engage the auditees in question, and recommend interventions that may address these challenges. In this regard, such joint oversight visits to the Free State, Gauteng, and Northwest have already taken place and will be reported on. I thank you, Deputy Speaker.
Thank you. Political parties wishing to make a declaration will now have an opportunity. The usual times will apply. The DA.
Deputy House Chair, honourable members, fellow South Africans. Our topic this afternoon is the financial management of municipalities, and the primary measure of how well municipal finances are being managed is the annual audit. The Auditor-General has a responsibility to report to Parliament the names of municipalities whose financial statements have not been submitted for auditing within 4 months of their year end, in other words, by the 31st of October. And then the AG must continue to report on these delinquent municipalities to Parliament every 3 months. And the AG's second letter was sent in February 2025, and this brought to light that there were 9 municipalities which had still not completed, the audit had still not been completed. And I think it's worth naming them. There was Kopanong, Mohokare, Masilongana in the Free State, also Case in the Northern Cape, Mafube, Maluti A Pofung, and Machabeng, Msunduzi in KZN, and Kahisano Molopo in the Northwest, caused by safety concerns, mandatory quality control delays, and auditee-related delays. And as our chairperson said, the AG has appealed to us as Parliament to address this problem, and in particular, the committees for the AG, for cooperative governance, public accounts, and finance. The problem, obviously, is much wider than just the late submission of the financial statements. It's the poor financial management of the municipalities. And to illustrate this, if you look at those 9 municipalities in the last 3 years of audits that have taken place, between them, we've got 10 disclaimed audit reports, we've got 1 adverse audit report, we've got 14 qualified audit reports, and there are 2 audits which are yet to be completed. And at this stage, not a single unqualified audit report. And to quote the AG, the audit outcomes for these municipalities have remained largely unchanged over the years, highlighting persistent gaps in financial accountability, governance, and service delivery. And I'm going to put that in very simple language. These municipalities are badly run, they don't deliver, they aren't improving, and they can't be trusted. And so it's not surprising that within the last 6 months, 2 of the mayors of these 9 municipalities have featured in news reports, one for allegedly trying to bribe a supplier, and the other for allegedly abusing municipal resources and then lying to Parliament about it. So the question before us is, how do we clean up the financial management of municipalities? And here are 4 practical steps that we can implement and should implement to do just that. Firstly, we must insist on merit-based appointments to make sure that the financial administrators are properly qualified at these municipalities. Secondly, performance agreements are crucial. They must be implemented and tracked for municipal managers and all of their direct reports. And those who consistently fail to deliver must be removed. Thirdly, where there are financial irregularities, there must be thorough consequence management, including criminal charges where appropriate. And to make sure that this happens, it must be mandatory that disciplinary outcomes are made public. And lastly, there must be national oversight of the consequence management to make sure that local municipalities are following through properly when there are irregularities. So I think if we do these 4 things, it'll make a significant difference to the quality of the financial management in local government. But there's a more important issue, because at the heart of this problem, there's a leadership issue. There's a leadership problem. And where the DA governs, 90% of those 30 municipalities receive unqualified audits, and 80% of them receive completely clean audits. Now, contrast this with the record of other parties. Most of these are ANC-led municipalities. Fewer than half receive unqualified audits, and only 1 in 12 receives a clean audit. In other words, a DA-run municipality is 10 times more likely to receive a clean audit. But this is not just about audit results. It's about governance, systems, controls, accountability, the efficient use of resources, and it's ultimately about service delivery. It's little wonder that so many people are migrating long distances to escape failing ANC-run municipalities, to live in municipalities which are governed by the Democratic Alliance. I thank you.
MKP.
House Chair, Umkhonto weSizwe Party would like to state without fear of contradiction that it attributes failures to submit financials to the AGSA by the municipalities to weak political leadership and lack of political will to administer consequence management and fast-track service delivery. Highly qualified and experienced CFOs are appointed in municipalities. They are well conversant with the MFMA and the development of financials. Yet every year the Auditor-General struggles to receive submissions. And even when submissions are received, at times the debits and credits are not in order. At times, they are in direct contrast with what the AG finds on the ground. This persists simply because no consequence management is administered and for the lack of submissions. A fallacy which must be cleared is that the challenge of non-submissions has something to do with the capacity to deliver, when it is simply a tactical maneuver to evade accountability on the usage of public funds. It's an act of blatant disregard of regulations orchestrated by an organized syndicate of corrupt looting agents of the so-called GNU, masquerading as executives and political leaders for the sole mandate of squandering public funds, leaving our people languishing in abject poverty. In the recent visit to municipalities undertaken by the Joint Committee comprising of COCTA, SCOPA, and SCOEC, what was revealed is that despite full-time paid officials and executives in municipalities, millions are spent on using consultants to do financials which themselves still come out with disclaimer findings. It's another opportunity and avenue to continue looting funds without delivering any results. Over 80% of CFOs are in acting capacities in these municipalities. It's deliberately designed so that there's no stability and accountability. When you go there, you find that the CFO who was acting has been replaced with another one, and they blame the previous CFO. It is a designed and orchestrated syndicate to just evade accountability of public funds. It's a money looting scheme which must be destroyed. As we advocate, it's a money-losing scheme which must be destroyed as we advocate for government to maximize internal capacity through the employment of qualified, dignified CFOs of integrity who are going to refuse manipulation by political parties and political leadership to do things that are unethical. Umkhonto Wesizwe Party contends that no intervention can remedy the situation for as long as the government of the day has a high appetite for corruption, incompetent, yet a low appetite for consequence management. As we gear towards local government elections, we call upon communities to liberate themselves from this tragedy of millions and billions in fruitless, wasteful and irregular expenditures which goes unaccounted for, yet taking away from the service they so desperately need. We make a clarion call to our people to put an end to this looting spree of criminal syndicates calling itself a government. The forest kept on shrinking and the trees kept on voting for the axe because its handle was made of wood, yet they thought it was one of them. That's one of the African proverbs that we want to live with. I thank you.
EFF.
Honorable House Chair, today we face a critical issue in local governance. Recurring findings in the Auditor-General's municipal audit reports. These are vital indicators of financial health, governance, and service delivery to citizens. These problems persist due to poor consequence management and weak political will for accountability, including late or missing audit submissions without penalties. Officials often enjoy political protection, and some are politicians themselves. For example, in Mfuleni municipality, a regional official also leads supply chain operations. These conflicts drive financial mismanagement, hindering duties and services. Municipal Public Accounts Committee structures and provincial standing committees on public accounts are often ineffective, led by heads responsible for mismanagement, writing off unauthorized spending without investigation and encouraging ongoing malfeasance. The Auditor-General has called on Parliament to use its constitutional powers to tackle these issues. Our committees must enforce House resolutions to stop erosion of fiscal discipline in local government. We must take decisive steps. The Standing Committee on the Auditor-General, Portfolio Committee on Cooperative Governance and Traditional Affairs, Standing Committee on Public Accounts, and Standing Committee on Finance should jointly investigate concerns, consult auditees, and suggest interventions. Municipalities must appoint qualified finance experts rather than consultants who drain resources, deliver short-term solutions, and fail to transfer skills. We must bolster internal audits and protect them from political interference to detect irregularities early. We must blacklist fraudulent companies and officials to ensure accountability and bar them from public contracts. We must revise the municipal funding model, as heavy dependence on conditional grants limits financial independence and planning. The Auditor-General should tie audit findings to both compliance and performance, viewing non-compliance as clear wrongdoing. Honorable House Chair, without firm action, mismanagement, impunity, and service failure will intensify. We in the EFF stand for the uncompromising principle to fight corruption, and that is exactly what must be done here. Thank you.
Thank you. The IFP.
Thank you, House Chairperson. The IFP recognizes the vital role of the Auditor-General in strengthening accountability, transparency, and integrity within our public institutions. The IFP notes with concern that the late tabling of annual reports undermines parliamentary oversight and weakens executive accountability, thereby eroding public trust in state institutions. We support the recommendation that Parliament should urgently explore mechanisms to ensure strict compliance with deadlines for the submission of annual reports. Compliance must be the norm, not the exception. The IFP also notes the importance of collaboration between oversight structures, including Standing Committee on Auditor-General, the Portfolio Committee on COGTA, SCOPA, and SCOF, in jointly interrogating the concerns raised. The committees must, within their mandates, address systemic weaknesses, engage auditees, and ensure timely corrective actions. As the IFP, we remain committed to a professional, transparent, and accountable public service. The protection of the office of the Auditor-General is not only a legislative requirement, but a moral imperative, as it safeguards the principles of good governance and the responsible use of public funds. Considering all the issues the IFP has raised above, the IFP accept and support the reports. I thank you.
Thank you. The PA.
House Chair, the Patriotic Alliance express our full support for this report. It is imperative that all government entities, particularly local municipalities, comply fully by submitting all documents requested and required by the Auditor-General. The failure to do so, whether through late submissions or the complete absence of submissions, seriously undermines the functionality and effectiveness of the Auditor-General in carrying out its constitutional mandate. We agree with the recommendation that Parliament must intervene decisively to ensure accountability. It is not enough merely to note late submissions. There must be tangible consequences for non-compliance. Furthermore, Parliament must act and to establish mechanisms that will prevent such failures from occurring in the future. Accountability is the cornerstone of good governance, and without it, service delivery and public trust in government are gravely compromised. Thank you.
Thank you. The FF Plus.
Thank you, House Chair. Chairperson, municipalities not submitting their annual financial statements on time is an unacceptable state of affairs. The Auditor-General's letter spells it out. Audit finalization is still being held up by chronic delays. This isn't just a technicality, it's a legal obligation under Section 1262 of the MFMA. Accounting officers must get their financial statements in for auditing within 2 months after the end of the municipal financial year by 31 August. Yet, many are simply not meeting this deadline. To put the problem in perspective, as at 30 November 2024, there were still 44 audits outstanding. Even by 31 January 2025, a full 5 months after the year end, 9 of those audits remained incomplete, and 5 were directly due to late submissions. The Mafube local municipality in the Free State stands out as a particularly worrying example. They hadn't even submitted their statements when the Auditor-General briefed the committee, resulting in a material irregularity being flagged. And to add insult to injury, this municipality has basically been under administration since 2017. The problem is especially pronounced in provinces like the Free State, North West, Northern Cape, Mpumalanga, and KwaZulu-Natal. This pattern of non-compliance is more than just a missed deadline. It's a breach of the MFMA, and it has real consequences. Late financial statements disrupt the entire accountability cycle. Audits and reports are delayed, transparency suffers, and councils and communities are left in the dark. But most importantly, these delays make it impossible for municipalities to plan properly, budget properly, and deliver the services our communities rely on. This, Chair, is the bill coming due for years of poor accountability, poor performance, and even poorer consequence management, guided deployment and revolving door practices, and now our communities are paying for it. This cannot be allowed any longer. Thank you.
Thank you. Action SA.
Speaker, the report before us highlights 2 of the greatest challenges facing our country: failing municipalities and the absence of accountability among public representatives and officials. On failing municipalities, the Auditor-General has made it clear The late submission of audited financial statements constitute non-compliance with the Municipal Finance Management Act. More importantly, it undermines financial accountability, weakens governance, and ultimately destroys service delivery. There's a direct relationship between the timely submission of credible financial statements and a municipality's ability to fulfill its mandate. Where submissions are late, service delivery is non-existent. Mafube municipality is a stark example where service delivery there has all but collapsed. On accountability, the Auditor-General notes that the accountability ecosystem must be activated to address the late submission of financial statements. It cannot be that municipalities repeatedly flout the law without consequences. Many of the worst offenders are repeat offenders, yet nothing changes and no one is held responsible. This Parliament and the committees tasked with oversight must step up to ensure accountability and real consequences for public representatives and officials who fail in their duties. Speaker, the submission of quality and timeous annual financial statements is the first and most critical step towards ensuring that municipalities deliver on their mandates. Where municipalities fail in this regard, there must be accountability. Action SA supports the report. I thank you.
Thank you. The ACDP.
Thank you, Honourable House Chairperson. In considering this report of the Standing Committee on the Auditor-General, the ACDP believes that this corroborates the lived experience of millions of South Africans who've had to endure little to no service delivery from municipalities on a daily basis. The late tabling of audited reports, irregular, fruitless, and wasteful expenditure in municipalities is an indication of a local government in crisis. The ACDP has called for the implementation of good governance based on the Singaporean model of meritocracy, pragmatism, and honesty. And this particular model is supported by the biblical injunction of having able, trustworthy men and women in local government who fear God and who hate dishonest gain. Honourable House Chairperson, we cannot have municipalities collecting rates and tariffs, but not giving the commensurate service to the municipal citizens. This House must ensure that the legislative frameworks are met to the full extent of the law, and those municipal officials who do not comply must also be held accountable. The ACDP supports the report. I thank you.
Thank you. UDM. Rise. Bosa.
Thank you, Honourable House Chairperson. Honourable members, in reading this report, one can't help feel that we are watching a similar movie. In the first instance, Auditor-General reports tend to go ignored, and often in many cases we end up with not only delayed reports, but a sense upon which many with impunity proceed with acts of corruption. The movie goes as follows. We deploy people to municipalities, and then post that, we ensure that the same deployed people end up looting in our communities. Now is the time for us to take deliberate action and stop speaking as if this is a problem that doesn't affect any of us, because all of us live locally, none of us live nationally. So I want to urge a number of key critical interventions, because as the report speaks to the municipality of Mafube, meaning a new dawn, let us bring a new dawn to all of our municipalities, because when they fail to comply with audit opinions, we end up with effectively disinvestment in those municipalities, and rural municipalities are left without any jobs, leaving people to stay in hunger, and ultimately clinics being dysfunctional. So here are first few things. One, we need to appoint leadership and stop moving failed people who have gone from municipality to municipality to other municipalities. Secondly, I support the recommendation of the report that the committees need to enact stringent and more effective actions for those who are found to have delayed reports. Thirdly, we need better political leadership. At this point in time, many municipalities have got multiple ports of entry where ultimately it's either the Ministry of COCTA or the presidency, etc. These problems in the provinces that are listed, we need to take deliberate action to make sure those who are found who have not complied with the AG are held accountable. Lastly, I think the AG complains every year about close to 50 billion rands of wasteful and fruitless expenditure. Isn't it about time that we partner with SAICA and begin to say, rather than municipalities having to pick their own CFOs, let us pick from the South African Institute of Chartered Accountants to send competent people to monitor audits and make sure there's compliance. Honorable
Thank
members,
you. Honorable
we need
Wynand.
action. Thank you very much.
ATM, Al-Jamal, the NCC, the PIC, the UAT, Good, the ANC.
Do livhuwa muthomphehi mudzulatshidulo. Miraḓo ya nnḓu I ṱhonifheaho na vhadzulapo vhoṱhe vha Afrika Tshipembe nga u angaredza. I stand before you today representing the African National Congress to express our unwavering support for the tabling of the report of the Standing Committee on the Auditor's General letter in terms of Section 126, subsection 4, and Section 133, subsection 2B of the Municipal Finance Management Act, number 56 of 2003, dated 11 July 2025. It is clear that the report is not merely a document, it's a call of action for accountability, governance, and service delivery in our municipalities. It highlights the persistent challenges at late submissions and audit delays, which undermines transparency, weaken public trust, and compromise the lives of ordinary South Africans. The ANC clarion calls for a capable, ethical, and developmental state cannot be overemphasized. This report reminds us that financial accountability is not just a technical issue, but also a matter of social justice and dignity. We note the following key elements in the report that are disturbing and deserve strong action from all those in leadership to whom the implicated municipality report. The non-compliance with financial reporting deadlines, where 10 municipalities failed to submit their annual financial statements on time, with one municipality not submitting at all. That on its own is a direct violation of the Municipal Finance Management Act. The inability to finalize the 9 audits by the stipulated deadline due to factors such as late submission and operational challenges highlights incompetency that disrupt governance and service delivery. The lack of significant improvement in audit outcomes over recent years reflects entrenched weakness in financial management and governance. Late submission and audit delays directly affect municipalities' ability to plan, budget, and deliver essential services, eroding public trust. We acknowledge the good work done by the Standing Committee on Auditor-General and the Office of the Auditor-General itself. In conclusion, we further urge this August House to adopt the report. Ndo livhuwa, mudzulatshidulo.
Thank you. I now recognize the Honorable, the Acting Chief Whip.
Thank you, House Chairperson. I move that the report be adopted and supported by the.
Honourable members, the motion is that the report be adopted. Are there any objections? MKP?
Please note the objections of Mkhonto Wesizwe. Thank you.
Thank you. With that objection noted, the report is agreed
What
to.
happened to your dress code? Your dress code is not consistent today.
Honourable Darkmore, you're a whip. Please don't unmute without asking for permission. The secretary will read the 5th and 6th orders together.
Consideration of report of Portfolio Committee on Correctional Services on oversight visits to KwaZulu-Natal Province from 25 to 28 February 2025. Consideration of report of Portfolio Committee on Correctional Services on oversight visit to Pollsmoor Correctional Centre.
To introduce the report, the Honourable Ramolobeng.
Thank you, House Chair, honorable members. Oversight visit to correctional centers is one of the tools the committee is using to assess the performance of the Department of Correctional Services and to keep members of the committee abreast with the day-to-day operations on the ground. The visit helps members to understand the challenges and frustrations the correctional officials in the cold face of service delivery and to make appropriate interventions where possible. Members, between the 25th and the 28th of February 2025, the committee visited 6 correctional centers in KZN and again visited Pollsmoor Correctional Center in the Western Cape on the 22nd April. The focus on the visit was on infrastructure, rehabilitation, skills development, and social reintegration of offenders. In all these visits, the committee invited the Department of Public Works and Infrastructure as the custodian of all government buildings. Honourable members, various themes emerged from this oversight visit, and they included, amongst others, kitchens, mental health, offenders, overcrowding, foreign national inmates, management issues, contrabands, vacancies, eye hygiene, in remand detention, and bail as less than 1,000 rand. Infrastructure and general maintenance to conclude. These themes are not only unique to correctional centers in KZN and Pollsmoor Correctional Center, but they persist also in some of the management areas we have visited to date. The state of kitchens in some of the centers visited in KZN was a serious concern for the committee. The committee found non-functioning equipment, including ovens, stoves, pots, and grills in the facilities visited. In Durban-Westville Medium A, half of the equipment were not functioning, and the state of the kitchen itself was not conducive for preparing meals for inmate or for anyone in that matter. The committee resolved to request the department to close that kitchen for renovations. Members, the level of overcrowding differs from one management area to the other, as well as one correctional center to another. Overcrowding rate, especially in Durban-Westville management area, was 192%, while at Eshowe Correctional Center, overcrowding stood at 11%. In Pollsmoor Correctional Center, the committee noted with concern the level of overcrowding, especially at remand facility, which stood at 243%, as well as the female center, which stood at 249%. The only facilities visited that were not overcrowded was Ebongweni Super Maximum Correctional Facility in KZN and Pollsmoor Medium C. Ebongweni has a capacity to accommodate 1,536 offenders, but at the time of the visit, it only housed 673 offenders. While Pollsmoor Medium C was 62% occupied, the committee has encouraged the Department of Correctional Services to find creative ways to use available space to lessen overcrowding. The infrastructure and general maintenance in some of these facilities visited is a concern for the committee. Some of the facilities need serious and urgent upgrades and renovations. The committee noted that lack of regular maintenance leads to deterioration of some of these facilities. The committee was also concerned with the general state of infrastructure at Kalagabusha Correctional Center and has urged the department to work on speedily renovating that facility to ensure safety and humane conditions for both offenders and officials.
In Pollsmoor, the committee found that the dilapidated infrastructure in that facility was causing constant leakages from the roof. The staff accommodation was also dilapidated because of the lack of maintenance by DPWP. On contrabands, the committee noted with concern the number of contrabands found in some of the correctional centers visited, especially cell phones, drugs, and dagga. In KZN, the committee was particularly concerned with the number of cell phones found in Eshowe Correctional Center, given the low number of offenders in that facility. While in Pollsmoor, the department reported that 2,444 cell phones and 6,891 Mendrax tablets were confiscated. The committee has requested the regional commissioners of both KZN and the Western Cape to come up with an action plan to stop contrabands from entering into correctional facility in addition. In conclusion, the general condition in some of the centers visited were fairly good, including Pollsmoor Correctional Center, whilst others were in a bad state, especially in Kalagabusha in KZN. The committee has encouraged the management of Pollsmoor to ensure that the terrain where officials are accommodated is also kept clean. House Chair, I present the committee report for consideration and adoption by the House. I thank you.
Thank you. Political parties will now again have an opportunity to make declarations on these reports. The DA.
Honourable Chairperson, honourable members, our recent oversight to Pollsmoor and KwaZulu-Natal have shown us both the potential and deep crises of our correctional system. At Pollsmoor, we saw good initiatives. The audiovisual remand system helps ease pressure on the courts. The mother and baby unit protects infants from the harsh prison environment. The skills workshop producing quality furniture shows what rehabilitation can achieve when it works. But these positives stand in the shadow of overwhelming challenges. Overcrowding remains the single biggest crisis. Pollsmoor at 175% capacity, the remand section at 234%, and the female centre at a shocking 248.6%. In KwaZulu-Natal, the situation is no better. Overcrowding undermines safety, dignity, and rehabilitation. We also saw prejudice against vulnerable groups, including women and members of the LGBT community, something this committee cannot ignore. Infrastructure is another major concern. The buildings are decaying, hygiene in communal cells is unacceptable. Contraband, including thousands of cell phones, highlights severe security risks. Just in yesterday's Daily Maverick, a highlight said cell phone analysis linked accused murderer and inmates to the fatal hit on the state prosecutor Tracy Brown. This is the risk that contrabands pose. These problems are not isolated. They are systemic. One of our key recommendations is that the Department of Correctional Services must take greater ownership of maintenance, instead of relying only on the Department of Public Works and Infrastructure. Yes, the fiscus is under constraint, but financial pressure cannot forever be used as an excuse to do nothing. The bakery at KwaZulu-Natal in Impangeni proves the point. In February, during the oversight visit, it was non-functional. I visited this facility again 6 months later in August, and it was still not functional. This is not progress, it's stagnation. Every day that bakery lies idle is a lost chance to save the department money and to rehabilitate inmates. Colleagues, our oversight is not a tick box exercise. We are relentless. We demand clear timelines, real commitments, and accountability. Our criticism is not meant to break down, but to build up. We want the department to succeed because rehabilitation, security, and justice are in the national interest. A well-functioning correctional system and the safety of our people depends on us turning oversight findings into visible change on the ground. And that is precisely what this committee does. Thank you.
Thank you, the MKP.
I rise on behalf of those who believe in justice, security, and the rule of law. Our recent oversight report as the Correctional Service portfolio confirms every single failing that we have been shouting from these benches by the feckless government. It's a catalogue of catastrophic collapse, and we place the blame for this disaster squarely at the feet of this government and its failing dangerous ideology. We declare that this report proves your soft-hearted approach has created a security nightmare. The rampant contrabands, the escape, and the collapsed infrastructure at Westville, Pollsmoor, and Kalagabusha are the direct result of a system that prioritizes criminals' right over public safety. Your obsession with rehabilitation over punishment has left our prisons dangerously overcrowded and understaffed. You have created a revolving door of crime with a 94% reoffending rate because there's no deterrent. Criminals are not afraid of our holiday camp prisons. Your neglect is a national scandal. The non-functional ovens at Epongweni, the unresolved storm damage, the suspended maintenance contract. This is a deliberate dereliction of duty that endangers both officials and inmates. Your handling of foreign national is a betrayal of South African citizens. Our prisons are overflowing with foreign nationals, yet you provide them with a tailored program that, while our South African communities lack basic services. We demand their immediate deportation, not their rehabilitation. They have separate sections and cells similarly to union buildings. The corruption you allow is systemic. The Thabo Pesta scandal was not an anomaly. It is a standard. Your refusal to implement mandatory public lifestyle audit for all senior officials makes you complicit in this corruption. This report is your indictment. This is proof that your philosophy has failed. You have coddled criminals, abandoned victims, and bankrupted our moral authority. You are not a patriot. We demand an end on this insanity. We demand prison that punish and deter, and that protect the public. We demand immediate deportation of foreign national offenders. We demand a system that puts safety of our people first. The era of weakness is over. It is time to restore justice. I thank you.
Thank you, the EFF.
Thank you very much, House Chair. The oversight by Correctional Service Committee revealed quite a number of inefficiencies in operations in that centers. Almost all facilities we visited in KZN and later Pollsmoor facility are overcrowded. Pollsmoor is at 243% overcrowding. Inmates in most centers are housed in terribly overcrowded cells and under inhumane conditions, including filthy linen and insufficient beds, forcing some of the inmates to sleep on the floor. Such overcrowding exacerbates issues such as gangsterism and easy smuggling of drugs and other contrabands. Sadly, young prisoners detained for minor crimes are often detained alongside hardened criminals, leading to further induction into crimes, entanglement in gang culture, and such transformation into being hardened offenders. Half of the kitchen equipment in all of the centers that we visited are either dysfunctional or non-existent. In KZN, kitchen certificates of compliance have either expired or have been open-ended for over 2 years without proper monitoring and updating by municipalities. Facilities such as Kalagabusha Inter Alia has bakeries built which remained for 2 years dysfunctional despite the department committing to self-sufficiency. The department claims budget constraint, when in fact proper allocation of funds towards utilizing these bakeries would help in self-sufficiency and rid the department of exorbitant standards, such as that of bread, as it is the case currently. Smuggling of contraband remains department's worst nightmare. There appears to be no clear strategy to curb such.
In KZN only, over 11,000 cell phones have been confiscated from cells in less than 12 months. Unfortunately, with no accountability, it's clear confirmation that the department is unable to manage center securities, its officials and staff. The amount of contraband confiscated each time there is a raid, it's a clear suggestion that greater involvement of officials than they are ready to admit. In-depth probes are essential. Of particular concern is Ebongweni, which is a maximum correctional center. Sewer pipes and other structural dilapidation is a cause for concern, while DCS and Public Works continue to play blame games on infrastructural maintenance issues. Telephone lines are not operational in most of the centers, making it difficult for inmates to contact their loved ones. Educational programs and skills transfer initiatives are appreciated. More inmates need to be encouraged to be and assisted to enroll for these programs as an effort to assist their rehabilitative progress. On the basis of the aforesaid, it is recommended that more unannounced oversight visits be conducted to ensure authentic assessment and to make oversight more insightful and truthful. Pre-announced nature of oversights leads to choreographed experience where authorities predetermine areas where they are going to show us, thus preventing us from full uncensored view of the operations.
Thank you, Honourable Member. Your time has now expired. The IFP.
Thank you, House Chair. The visit highlights both persistence and agent challenges confronting our correctional system. In KwaZulu-Natal, the committee found overcrowding, severe infrastructure backlogs, understaffing, and security vulnerabilities.
Honourable Markey, are you still with us? Honourable Khadebe, are you in a position to proceed?
At Pollsmoor, the situation is equally dire. Such conditions are not only inhuman, but also unconditional. The committee further noted dilapidated infrastructure, hygiene failures, and the shocking number of remand detainees with bail set at less than 1,000. This crisis demands agent collaboration across the criminal justice system to ensure that those who cannot afford minimal bail are not condemned to indefinite detention. We are encouraged by positive initiatives such as skills development workshops, agricultural programs, and the establishment of a separate mother and baby unit. This demonstrates and rehabilitation is possible when properly resourced, but these isolated successes cannot compensate for systematic neglect. We call for targeted investment in infrastructure upgrades in both KwaZulu-Natal and Pollsmoor, agent filling of vacancies and all levels of correctional services, stronger partnerships with the Department of Justice, Social Development and Basic Education to address remand detainees, juvenile offenders and social reintegration, and a renewed focus on rehabilitation as the cornerstone of correctional policy. Overcrowded and collapsing prisons do not make South Africa safer. They merely warehouse poverty and despair. In consideration of what we have raised, the IFP support the reports. I thank you.
Thank you. The PI.
Honourable Speaker, honourable members, honourable patriotic South Africans, the Patriotic Alliance strengthens its role as a governing partner in the government of national unity. Following Oversight's visit to 10 correctional centres in KwaZulu-Natal, Pollsmoor Correctional Centre in the Western Cape, the visit involves direct engagement with incarceration realities, calls for urgent coordination, action beyond mere acknowledgement. The visit revealed a crisis of overcrowding, largely caused by undocumented foreign nationals. Speaker, ons strongstelsel is besig om te kreun onder die gewig van wansbeheer, oorbevolking en 'n gebrek aan political wil. In sommige sentrums is daar meer mense as beddens, meer siekte as medies. en meer wanhoop as rehabilitasie. Speaker, ek wil dit duidelik maak, ek praat nie van bo af nie. Ek as 'n eerbare lid van hierdie huis het self baie jare in die tronk gesit. Ek ken daai koue mure. Woorde soos pantiet is nie helpful vir ons correctional diens of mense wat in correctional sit nie. Dit rehabiliteer nie, dit breek af. So asseblief lede, kom ons refrein. Ons mense sit nie net vas agter tralies nie. Hulle sit vas in 'n stelsel wat lankal moes verander het, van prison af na correctional services. A coordinated plan will address overcrowding due to undocumented foreign nationals through fast-track legal processing and deportation when necessary. En vir die mense wat sê, ja, maar dis net gevangenis, ons sê elke mens het 'n reg op waarheid. En as jy in die tronk sit, moet jy nog steeds
Agbare lid, die tyd is ongelukkig nou
Ek
verstrek.
wil net ook sê vir die mense in Westbury, ons sien die polisie skiet julle ons
Dankie,
saam met julle.
dankie. FF Plus,
Voor mannen 5 minuten missen.
House Chair, the findings in these reports paint a stark picture of historic and current systemic failures, highlighting pervasive overcrowding across multiple facilities with rates reaching alarming levels, such as Pollsmoor's remand facility at 234%, the female centre at 248%, and Durban Westville at 191% overcrowded. A recurring and deeply concerning issue is the dilapidated infrastructure, from constant roof leakages and compromised ablution facilities to broken windows and peeling paint, affecting inmate and staff safety. Many kitchens suffer from non-functioning equipment and expired compliance certificates, jeopardizing nutritional services. Furthermore, the scourge of contraband, particularly cell phones, for example, 2,444 recently found at Pollsmoor, 3,172 at Durban Westville, and various drugs remain rampant, indicating serious security breaches, but the fact that those were found should be noted. Critical staff vacancies, including security officers and professionals like doctors, persist department-wide, hindering effective operations and rehabilitation efforts. The continued detention of remand detainees on low bail amounts also exacerbates overcrowding and fiscal strain. While these reports confirm the deep-seated challenges inherited from decades of mismanagement and corruption, the efforts under the current Minister of Correctional Services, Dr. Pieter Groenewald, and the National Commissioner cannot be ignored and must be acknowledged. Surprise site visits and inspections, a greater focus on self-sustainability, and better overall management have already started to show positive results. The commitment signals a crucial shift from the inherited status quo. The committee has observed positive changes, such as the audio-visual remand system and dedicated mother and baby units at Pollsmoor, and this should be noted and applauded. We should work together towards a truly functioning and rehabilitative correctional system. I thank you.
Action SA.
Thank you, Chair. We sit here making declarations while everyone has already declared defeat and no one has a solution. 2 days ago, 3 days ago, the minister declared defeat. He said he feels like an artisan that has no tools. A couple of days later, I spoke to the president right here, and he too said that most of these gangs and most of the crime that we see unveiling on the Cape Flats is as a result of what is happening in our prisons, specifically Pollsmoor prison. So the top leadership knows about it, but nothing gets done. There's absolutely no accountability, no responsibility, no rehabilitation, and the blame game continues. No ways to measure the impact of rehabilitation as net as a premature criminal, and you graduate there as a seasoned with a certificate, a graduate in gangsterism. Oversight reports a horror show at this point in time. Pietermaritzburg Medium B, built for 316 inmates, now holds 480. 342, this we know, foreign nationals, each costing South African taxpayers 17,000 every month. Durban Westville, built for 5,341, crammed with 10,222, over 1,000 foreign nationals. We've been singing the song for the longest time ever. Skills programs has collapsed. Reintegration is not even monitored. Inmates walk out holding nothing but hardened criminal records. The results, prisons are revolving doors of gangsterism. 30 minutes from this house, on the Cape Flats, children are dying, being gunned down by the hour, families destroyed and communities torn apart every single hour. Action SA says, enough of this. We must rid our prisons, like we said before, of foreign nationals, restore real rehabilitation. I'm not sure if that's ever going to happen, and end overcrowding. For that, Honourable Speaker, the only solution is strong, decisive leadership with no excuses, which this country lacks.
Thank you, Honourable James. The ICDP.
Honourable House Chairperson, the ACDP notes with grave concern the findings of this portfolio committee following oversight visits to KwaZulu-Natal and Pollsmoor Correctional Centre. These reports expose systemic neglect, administrative inertia, and a troubling disregard for constitutional obligations. Over the past 5 years, procurement irregularities have involved inflated contracts and unauthorized spending, as well as the failure to adhere to constitutional, legislative, and regulatory provisions governing public procurement, as noted in the 1.6 billion IDT contract. The ACDP welcomes the suspension of some 1,679 officials in correctional services, with 586 dismissed for offences ranging from procurement fraud to abuse of medical privileges for wealthy inmates. We assert that correctional funds are not scarce. They are just being consumed by corruption rather than correction. In KwaZulu-Natal, the committee encountered a correctional kitchen operating without a valid compliance certificate since 2020, an unacceptable breach of health and safety standards. At Pollsmoor, the committee found overcrowded remand sections, under-resourced medical clinics, and vocational programs that fail to equip inmates for reintegration. The mother-to-baby unit, while commendable, suffers from inadequate support structures, and these conditions undermine rehabilitation and violate the dignity of those in custody. House Chairperson, correctional centres must not become warehouses of despair, but spaces for justice, restoration, and human dignity. As kingdom builders, the ACDP will continue to advocate for a correctional system with values which build and correct, rather than those which are corrupt and inept. The ACDP supports this report. Thank you.
Thank you. The UDM. Rise.
No declaration, Chair, we support.
Thank you. Bosa.
No declaration, Chair, we support the report.
Thank you. The ATM. Al-Jamar. The NCC. The PAC. The UAT. Good. The ANC.
Honourable Chair, honourable members, the African National Congress rise in strong support of the oversight report of the Portfolio Committee on Correctional Services following its visits to correctional centres in the KwaZulu-Natal and at Pollsmoor. Together, these reports paint a sobering picture of the state of our correctional facilities and services. The facilities are under immense strains. However, there is room for improvement that is directly in line with the ANC vision for a humane, rehabilitative and developmental correctional system. In the ANC, we hold the view that human dignity comes first, and correctional centers cannot be turned into warehouses of human beings. They must be centers of rehabilitation, skill development, and preparation for reintegration. In both KwaZulu-Natal and Pollsmoor, the committee observed important advances. These include bakeries, workshops, and agricultural projects that equip offenders with technical and entrepreneurial skills. Schools that enables inmates to achieve matric and even tertiary qualifications, and community correctional programs that link rehabilitation to services in our communities. These initiatives embody the ANC belief in restorative justice and the transformation potential of correctional services. We commend further innovations observed, such as the audio-visual remand system at Pollsmoor, which reduce risk and cost associated with transporting detainees, and the detective mother and baby unit, which ensure that infants are not exposed to the harsh environment. In KwaZulu-Natal, we note successfully zero escape records, community outreach projects, and strong efforts to promote rehabilitation through accredited training. These are in line with the ANC policy priorities of a safe, secure, and right-based correctional system. However, Honorable Chair, these reports also lay bare deep challenges that undermine progress. Overcrowding remains a severe challenge across all correctional centers, with KwaZulu-Natal's facilities operating beyond capacity and Pollsmoor recording an overcrowding rate of more than 175%. Overcrowding compromises rehabilitation and places unbearable strains on officials and infrastructure. We also noted the disturbing contrabands from cell phones to drugs, which weaken security, discipline, and rehabilitation pin our correctional facilities. We have also noted the shortage of professionals such as social workers, doctors, across the centers, which threaten effective rehabilitation. We support the committee's call for urgent filling of vacant and funded posts. We support the recommendation of merit-based promotion and structural training to build management capacity. Another major concern was the state of the infrastructure, particularly the state of kitchens, leaking roofs, houses for officials, malfunctioning perimeters, fencing. These conditions pose a safety and security risk to the inmates, but as well as to the staff. We call on the Department of Public Works and Infrastructure to implement urgent maintenance of the correctional centers and the accommodation of staff, and invest in modern technology such as body scanners and mobile phone jammers. Honorable Chairperson, in our duty through robust oversight, it's our duty through robust oversight to ensure that our correctional centers move closer to becoming the institutions of hope and rehabilitation rather than despair and neglect. We are of the view that the reports are a true reflection of the committee observation and recommendations. The ANC therefore support the adoption of these reports, confident that their recommendations will strengthen the correctional service systems, uphold the rights of inmates, and support the work of our officials. I thank you.
Thank you. I now recognize the Honorable Chief Whip.
Thank you, House Chairperson. I move that the report be adopted.
Honorable members, the motion is that the reports be adopted. Are there any objections? Honorable Douglas.
Please note the objection of Mgunto Isizwe Party. Thank you.
That objection
Rejected.
noted, the reports are agreed to. Honorable members, that concludes the business for the day. You're requested to stand and wait for the chair and the mace to leave before you leave. This house is adjourned.